Good morning. This is the Board of Appeals, Town of Hempstead, August 20th, 2025, 9:30 meeting. Will everybody please stand for the Pledge of Allegiance? Mr. Chairman, do you have any opening remarks?
I do. I believe I see one or two people in the audience who have not had the pleasure of appearing before us. So we'll go through the routine and let you know how we conduct the hearings. All right? So first, we will call for any adjournments. If there are no adjournments, we'll start with the calendar. Ordinarily, the calendar, we start with renewals, and then we will go through the regular calendar. This is not a court of law. As a result of that, we are not constrained by the strict rules of evidence. We accept just about any kind of evidence if it's reasonable. If there is anyone here in opposition to any of the applications, you'll be given the opportunity to voice your opinion. After the applicant makes their case, then we call for any people who are in opposition, and then we end the hearings by having the applicant or their representative sum up. I'm sure I'm missing something, but there are so few people in the room, I think we can start calling the calendar. Are there any applications for adjournment, Patrick?
Mr. Chairman, there are no applications for adjournment
Okay.
this morning. First, we'll be calling case 43425, Roosevelt Carlos Bolanos, renewal of grant to maintain
620?
two-family dwelling, also known as 68 White House Avenue.
Okay.
Good morning. My name is Carlos Bolanos, 68 White House Avenue in Roosevelt.
Okay, Mr. Bolanos, this is a renewal of a grant to maintain a two-family dwelling in Roosevelt, is that correct?
It is correct.
And the building department inspected the premises on June 20th of 2025, and they found that all conditions previously imposed by this board are being complied with. Do you have anything else you'd like to add, sir?
No, sir.
Okay. Any other questions from the board? If not, do I have a motion?
Mr. Chairman, I would just move that the hearing be closed, that the matter be placed on the decision calendar. Mr. Bolanos, you'll be notified by mail of the board's decision once it's rendered.
Second?
Awesome.
Second? All in favor?
Aye.
Any opposed?
Have a
Any
nice day.
abstentions?
Thank you.
Have a good day.
Next, we have case 43525, West Hempstead, Maria Tzakis, renewal of grant to maintain two-family dwelling, also known as 95 Maplewood Street.
Good morning. I didn't hear you say your name, but I would assume you are Maria Tzakis? The applicant, okay. So this is a renewal of a grant to maintain a two-family dwelling in West Hempstead. The building department inspected your house on June 6th of 2025, and they found that all conditions previously imposed by this board are being complied with. Do you have anything else you'd like to add, ma'am?
Can you just give your name and address again? I wasn't sure if we got it.
95 Maplewood Street, West Hempstead.
Your name?
Maria.
Maria
Very loud,
Speak
please.
very well.
Can't
Tzakis.
hear you.
I can speak English very well.
Okay, all right.
That's okay, just say your name and your address so she can get it onto the record.
Okay. My name, Maria Tzakis, 95 Maplewood Street, West Hempstead.
Okay.
Very well done.
I will then repeat what I said before. The building department inspected the house on June 6th of 2025 and found that you're complying with all conditions previously imposed by this board. Do you have anything else you'd like to add, ma'am?
Anything else you want to tell us?
Can I tell you maybe I make permanent two-family?
We'll take that under consideration, ma'am, but ordinarily, we don't make it permanent, because if we did and you sold the house, somebody else might misuse the property. Okay?
Okay.
We'll say
All right.
Mr. Chairman, I would just move that the hearing be closed, that the matter be placed on the decision calendar. We will send you the decision in the mail, letting you know about the renewal of this two-family house, okay?
Two-family, you know a betterment, I can't make it.
Not generally speaking. We have to keep it on our list to monitor it.
Okay.
All in favor?
Aye.
Any opposed?
Have a nice day. You're finished.
Thank you so much, thank you.
Go ahead, Patrick.
Next, we have case 43625, Baldwin, Gladys Beltran, and Fanny Velasco. Renewal of grant to maintain two-family dwelling, also known as 479 Emerson Avenue.
No one here, second call.
Next, we have case 43725 through 43925, Elmont, Allen, and Kimberly Schauman. Renewal of grants, use variance to maintain detached garage conversion to behavioral consultant's office with rear and side yard variances, waiver of off-street parking, maintain 4-foot-high fence within the clear sight triangle, also known as 140 Evans Avenue.
My name is Alan Shamoun, 140 Evans Avenue, Elmont, New York.
Good morning.
Good morning.
So, sir, you are here for the renewal of a grant that allowed you to use your detached garage as an office for behavioral consultants and a few other things related to that, parking and some setbacks.
Correct.
Okay. On 6/11, which is June 11th, the building department inspected the premises and found that you were still complying with all the previously imposed conditions. Is there anything else you wish to tell us?
I just would like to make two requests. One, of course, the obvious, which is that I request and hope that you grant all three variances. The second is a request, if possible, to grant the variance for the clear sight triangle with the fence in perpetuity, just because it is a fence that's part of the house, and we don't intend to, regardless of the use of the garage, the fence we need for the property itself. So it would be great to not have to renew that every 5 years.
Okay, I understand. We'll take it under advisement. As a general rule, particularly in clear sight triangles, we don't grant them permanently, and I'll explain to you the reason is that you have fenced 4 feet. We've determined that as you have it, it will not be dangerous to vehicular and or pedestrian traffic. However, if you were to sell your house and the next person come along and even potentially innocently decides, you know, I got little kids, I want a 6-foot fence, solid, etc., which is very common, then we wouldn't know about it and it could be creating a safety issue. So we grant these temporarily because every 3 to 5 years, the building department, usually 5, goes out and inspects it to ensure that it's still see-through and 4 feet. So we'll take it under consideration, but the likelihood, I'm guessing, is not great. Okay?
I appreciate that. Thank
Anything
you.
else you wish to add?
No, thank you.
All right, if there are no further questions from the board, is there a motion?
I move the hearing be closed, the case placed on the decision calendar.
Which one
When the
was
board
that?
renders its decision, you
This
will be
one?
notified in writing by the mail.
Second? All in favor? All
Any
right, sir, have a nice day.
Thank you, you too.
Right. Yeah.
Next, we have case 44025, Merrick Barbara Wood, a variance front yard setback on Northridge Avenue, construct a second-story addition to dwelling, also known as 1550 Northridge Avenue.
Give your name and address. You've been sworn in?
Yes, I have.
You can give your name and address.
Good morning, members of the board. My name is Ashley Lokianese from Lowdown Expediting. Our office is located at 131 Berkeley Place in Massapequa, New York. I'm here today on behalf of my client, Ms. Barbara Wood, who is the owner and occupant of the subject property located at 1550 Northridge Avenue in Merrick, New York. We are here today as a result of an application filed with the Building Department under application 24-11496 for a proposed second-story addition and HVAC. The proposed second-story addition is for a proposed family room on the first floor, and then the addition, there will be the 3 bedrooms, 2 full bathrooms, and 2 walk-in closets.
Ms. Lowe, one second. The first floor addition does not require any variances, or does?
So the addition will just have the first floor bedroom changed to a family room. There is no, the first floor is not changing at all.
There's no variance for the first floor, correct? Okay, keep going. Oh, since I stopped you. And is the second floor addition completely within the footprint of the first floor?
Yes,
So the first floor already has a variance for the front yard on Northridge?
yes, the front yard setback is existing, and the second addition will go above that. So the proposed front yard setback does not meet the required 25-foot setback, having 18 feet on Northridge Avenue as an existing front yard setback and proposed for the second story as well. This requires 7 feet of relief. This is a corner property, but the front yard setback on Henry Street does comply with zoning code. As I stated, the addition is going above the existing first floor, so this is not changing the current condition.
Ms. Lowe,
Is our only request.
if the first floors are at 18, and I note here there's a cantilever, doesn't that usually stick out further than the first floor? How is the first floor 18, the second floor 18, and there's a cantilever?
Not in the front of the house, yeah. In the front.
But if the existing first floor is 18, and you can't leave her out, it would have to change. The second floor would be shorter. But she said it wasn't.
Your plan would indicate that the current front yard is 20 feet and not 18 feet.
John,
I apologize. Yes, you're correct. There is a 2-foot cantilever on the front floor.
doesn't that mean there's a second story addition? I mean, a two-story,
Second story.
okay.
No,
So it's not fully
Yeah,
within
it's
the
a second
footprint.
story
That's the
No.
thing. It's not fully in the.
I apologize.
got you.
Yes, you're correct.
Pushing out 2 feet further into the front yard setback.
Difference if there's
Yeah.
cantilever.
Anything else you'd like to add?
That's our only
Any
request this
any
morning.
other question from the board? If not, do I have a motion?
Are all the permits closed on this?
There are no open permits. There's an open plumbing permit, I believe, which will be closed at the end of the inspection.
So the pool is in
Got that sheet?
compliance? Swimming pool is in compliance?
Yes.
Mr. Chairman, with that, I would move that the hearing be closed, the matter be placed on the decision calendar. Ms. Lowe, you'll be notified by mail of the board's decision once it's rendered.
Second, all in favor?
Aye.
Any
I was
opposed?
looking for my pencil.
Put kitchen and barbecue. Horizontal.
Next, we have case 44125 Oceanside, Robert Dietz. Special exception to maintain second accessory structure, outdoor kitchen/barbecue, exceeding horizontal maximum on 2 sides, not permitted in the side yard, and with less than required side yard setbacks, also known as 551 Fur Place.
I'll trade you. Thank you. $40.
Dominic Minerva, Minerva and D'Agostino, 107 South Central Avenue, Valley Stream, New York, attorney for the applicant.
Robert Diaz, 551 Fur Place, Oceanside, New York.
The application before you today is for area variances and special exception to maintain a barbecue island. Subject premises is known as 551 Fur Place, Oceanside, New York. The owners are seeking to maintain a barbecue island that is located within the side yard setback and is a second accessory structure. The relief required are variances for side yard setback with 1.2 feet provided. Location within the side yard, although I'll note that the barbecue island is approximately 80 feet from the front property line, and it's right on the cusp of the rear yard. Special exception for the size, with 12 feet horizontal maximum permitted and 20 feet provided, and special exception for a second accessory structure, with the first structure being a shed on the opposite side of the rear yard. The barbecue island is only 3 feet high whereas accessory structures can be up to 9 feet high. It's behind a 6-foot-high masonry wall, followed by a 6-foot-high white vinyl fence. It's located partly along the garage wall in the rear yard of the premises to the west. It's our position that the barbecue island is not noticeable from the neighboring property to the west.
She said for
The neighbor to the west has a very large lot, half an acre, which is large for this area, as well as my client has about a third of an acre. And their dwelling on the property to the west is located significantly away from the budding property line, and their recreation area is even further on the west side of their house.
Mr. Minerva,
Yep.
excuse me, I'm sorry. Two things. The two sides are both 20s that are exceeding horizontal.
Yeah.
Say that again?
There are two horizontals you need. I assume they're perpendicular to, or parallel with one another?
Parallel.
And they're both 20?
And they're both 20,
Okay.
yeah.
And then the other question is, I thought when you were speaking early on, you mentioned that the barbecue island, whatever, was 8 feet off of like the front yard setback or something?
80 feet, approximately 80 feet
80.
from the front property line.
Yeah.
So
Great.
it's really, even though it's technically in the side yard, it's really kind of in the rear yard.
Good.
Understood.
That was my argument. Okay, I have some photos that I'd like to submit so the board can see the barbecue island. They were taken by myself on August 14th, 2025, and they fairly and accurately depict the barbecue island and the subject premises, in my opinion. I'm also going to submit an aerial photograph that was taken from the County of Nassau website that shows the general location of the house to the west, so you can see that
We'll
there's a
accept
distance there.
those.
Mr. Minerva, you need no relief for the covered screen and porch, correct?
Correct.
That is a,
Those are, everything's filed for.
right.
Everything has permits that need to be closed
they have
out.
to be closed.
But the inspector said that we need to resolve the barbecue island before we can close out all the open permits. That's the only structure that requires a variance. Then my client did contact the neighbor to the west. That's only the only neighbor affected. You see if you need to hear from him. My client, the neighbor, said he had no objection, but he felt uncomfortable signing a formal petition.
Okay.
So it's our position that the variance is a minor in nature, especially in light of the low height of this accessory structure, significantly below the fence line and wall line. Proposals in keeping with the active area will not be detrimental to surrounding property owners. And
Crazy.
we request your favorable consideration and remain available for any questions.
Wow, I just have a question. That is one beautiful, amazing outdoor kitchen barbecue. Did you build it, or did you have a company do it?
No, company,
You did it?
no, company.
Contractor.
Contractor built it.
Oh. Can you leave me the name of the contractor?
Sure.
Wow,
I've seen it. Yeah, I saw it.
that's beautiful.
It's nicely done. All right. Any other questions from the board? If not, do I have a motion?
Move that the hearing be closed, the matter be placed on the decision calendar. Mr. Minerva, you and your client will be notified by mail of the board's decision once it's rendered.
Second, all in favor?
Aye.
Any opposed? Little pizza oven? Pizza oven in the corner? Okay.
Oh, you did it?
Go.
Here, send this to Joe.
Take photos.
Next, we have case 44225, Merrick and Dio Gear. Variance, side yard, maintain a balcony attached to dwelling, also known as 3045 Whale Neck Drive.
Do you need to open
Yeah.
I'll make a motion.
Ms. Gaines, we have you sworn in from earlier, just your name and address again.
Side yard.
Mr. Chairman, before we go to this case, Ms. Lowe, can I make a motion that we reopen the prior case Ms. Lowe presented? I think there's one or two additional questions about the pool permit. So I would move, Mr. Chairman, that we reopen, pardon me, case number, hold on, case number 440-2025 in Merrick. It's the Barbara Wood case, so that we can ask just one or two additional questions.
Want to second that motion? Second. All in favor? Any opposed?
Go ahead, Mr. Pellegrini.
Ms. Lowe, the permit cert indicates that the swimming pool has an open permit.
So to my knowledge, the homeowners were told to close out the swimming pool prior to the summer starting, when we first pulled the search and filed the application. To my knowledge, they had scheduled the inspection.
Wait, to your knowledge, what?
What?
They had scheduled an inspection to close the permit for the pool.
So to your knowledge, it is still open, but you think they might have an appointment for the inspector to come close it, or you think it's actually that all happened and it's closed?
So the last I had spoke, they had scheduled an inspection. But I do not
Have
know
you,
the outcome
have
of the
you been
inspection.
to the house?
I have.
And is the pool properly enclosed, in your opinion?
It is, yes. It is, it's a tight backyard, but the backyard is completely enclosed. I've been in the backyard, I've taken photos. There's,
For future reference, when Mr. Pellegrini asked about that, we care particularly about pools because of the safety issues that are there. So when he asked you earlier about the pool, that's why he was inquiring. So just please be careful about those, because we do want to make sure everything's properly enclosed.
so we did have a discussion about it when I met with the clients to go to the house, to take photos, and to meet with them for signatures.
When was that?
I don't know the exact date, but it was, I've been there twice. First, I was there in January, and then I was there again, I believe it was sometime in May.
Mrs. First, does that indicate that the permit is still open for the swimming pool? Thank you.
And do you happen to know from your clients when this appointment is to
No.
finish it?
I was not contracted to close the pool out, or I just told
Yeah,
them that
it's
they
just
should
that the
close the
pool
pool.
is particularly important.
I understand. I was just hired for the variance hearing, but I did tell them that, pools were a big issue, and that all the different items that they needed in order to pass their inspection.
Do you know when the pool was installed?
I do not.
Becky's working on it.
Check this out, so you can walk out and fall. That's interesting.
Yeah. 23-7467. The pool was installed in 2023.
The permit was issued, but no inspections have been requested.
Okay.
See that there's a.
It's all open. No inspection.
But Becky, do your records happen to show when there is an appointment scheduled?
There's no request for inspections.
Okay. So obviously your client weren't quite forthcoming. So just let them know, and maybe that will.
I'll speak with the architect as well.
Who is the architect?
Kevin Daly.
Who?
Kevin Daly. Thank you. All right.
Yeah, because this is a construct case, so they're going to want to get that addressed. It's a construct, not a maintain, so obviously they want to go forward with this construction.
Oh, absolutely. Yeah, no, I'll have a conversation with them. I totally understand.
Okay. Mr. Chairman, with that, I would move that the hearing be closed, the matter be placed on decision calendar. Ms. Lowe, you'll be notified by mail of the board's decision once it's rendered. Aye.
Back to 442-25.
Okay. Good morning again. My name is Ashley Locunis from Mark Anthony Architects. Our office is located at 1563 Belmore Avenue in Belmore, New York. I am here today representing for my clients Dio and Ophelia Gear, who are the owners and occupants of the subject property located at 3045 Wellneck Drive in Merrick, New York. We are before the board today as a result of an application filed with the building department under 23-3514, which was filed and originally issued for a proposed partial second-story addition, proposed interior alterations, rear deck extension, and proposed front and rear balconies.
They did get a permit before they built that balcony?
Yeah, I'm getting there.
Because there's no open permit.
No, there is.
Not as of March 18th, 24.
This case is for a supplement to that open permit.
But I'm saying I don't have an open permit. I mean, the search sheet's a little old, so,
Yeah, so it's probably under applications, if that search sheet is old.
you're correct, there is an application. So
Yeah.
why doesn't it show the permit?
They didn't submit an updated record search.
Okay,
The building permit was issued in 2023, a supplement was filed after.
okay. Our search sheet's sort of old, so. All right, Ms. Lowe, go ahead.
Wait, Ms. Lowe, there, sorry.
I know. I will answer all your questions, though, but have it.
There appears to be a second-story balcony in the back and the rear as well as the front. Which one is before us? The front, so the rear is closed out.
They're all on the same application.
Oh, the rear just doesn't need relief.
Yes.
Are they,
Well,
you,
yeah, technically the side needs relief,
Okay, the other one.
but it's not the one in the back. It's the one along Bayberry Drive.
Along Berry Drive?
Yes, the property line along Bayberry Drive. If you look where it says the existing adjacent shed on the other property that's to the neighboring. No, it's-
Okay, let's do this. Ms. Lowe, you finish what you have to say. We're going to ask Ms. First to give us some input because there's some information in the records that we don't otherwise have. So I want to put that into this equation too.
I'll try to answer everything
Sorry.
I can, and then.
We'll try not to interrupt
anything.
anymore.
I want to interrupt one more time. No. The plot plan indicates, it doesn't, I don't, okay, I take it back. I won't interrupt you unless I have to.
Okay, go ahead, Ms.
So like I said, the application was originally issued for the proposed partial second-story addition, proposed interior alterations, rear deck extensions, and front and rear balconies. The application was initially permitted without having to go in front of the board and was issued on September 29th, 2023.
Including that front deck.
Yes, everything remained the same. A supplement application was submitted on January 12th of 2024 after several changes made in the field during construction. There is now a side yard setback variance as a result. The original approved side yard setback was 6.42 feet, which complied with the zoning standards. The side yard setback now shown on the supplement for the balcony is 4.8 feet, where 6.38 feet is the minimum required, for which we require 1.58 feet of relief. Mr. and Mrs. Gear are eager to get this project completed and have it inspected. The project has been going on for nearly 2 years now. There are no open building permits. However, there is an open plumbing permit, which will be closed out along the application should it be approved. This is our only zoning request for the day. That's the only item that has changed.
Okay. How can there be no open building permits if this was built as part of a permit?
Well, I mean, other than this
Okay.
application. That
Okay.
was what I meant.
Now, Ms. First apparently you were the plans examiner on this, and she showed us some of the notes that are in the records. So
Okay.
could you just explain to us what you know about this front deck, the deck we're talking about, as opposed to the rear?
The proposed balcony was first brought before the building department.
Wait, slow down and
The
talk loud.
proposed balcony, as we see it today, was first submitted to the building department for approval and was rejected by this plan examiner for the same side yard setback, because it required it required a side yard variance. The property, the design was then submitted so that the balcony would comply with the required side yard setbacks. And then upon issuance of the permit, a supplement was filed, which then we issued them an objection stating repeat of objection from the initial review of the application on June 28th, 2023. Side yard aggregate is determined by lot width at the building line, front width line, not at the street. The balcony was built as designed in the rejected plans.
So it was, they asked twice for it like this,
They asked for it like that on the
and it
first
got
submittal.
twice rejected like
It was
this.
rejected, they redesigned it to comply, and then built it anyway.
And they built it as the rejected model.
Yes. So our office had many conversations with the clients that, you know, this would trigger a variance. Ultimately, we ended up removing it. Seemingly, they were not going to build it that way. You know, they did not want to go for a variance in any situation before we had the permit issued or after, and then 6 months into building, they came into the office.
Is your client
and
a
said that
builder?
it was already built.
Is your client a builder?
No, they used they contracted out.
Well, you come before us a lot, so we're familiar with your integrity. I'm sure this is not a case you wanted to come here with either.
No, just we were very clear with the clients. There's been quite a bit of back and forth, and, you know, they're very nice people, and their daughter has kind of spearheaded their project for him. They've been out of the home for a while.
Well, they're not in the house?
As of a couple months ago, they still were not in the house.
Was anyone?
During the building, they did not live during construction. So they were eager to get back into the home, but ultimately, it seems as though when they decided to start building, they decided that they wanted to make the change and did so in the field.
Is there a stop work order? Is that the deal?
Becky?
We got a stop work order.
I mean, there must be, because otherwise they would have just put some railings on it and called it good.
I think we got a violation and we're just told to stop, but it never got that far.
Building inspector, upon inspection, gave them they didn't give us a specific stop work order, told them to basically not.
Take it off.
Yeah, not continue, file supplement, go forward.
Yeah.
The photos that are in the file, is that the way
I'm going to say no to
it
this, Dad.
exists today?
I'm not going to, I
The
don't
photos
think we
that
should
I've got,
reward
yes,
that
those are the most recent files.
So,
They twice asked.
obviously, it's a safety issue, there's sliding doors and there's a balcony without a railing.
Well, we had to stop working, until we filed the supplement, we didn't have a
That
choice.
didn't stop your client.
Okay, I think we understand the case.
We don't have a choice, or else they would have issued a stop work order.
Go right
So,
ahead.
so, let me get this straight. So your client filed for this balcony with the building department,
Yes,
and they rejected it. And then you gave them a different plan, and then once you started building, you just did whatever you wanted. In other words, you just built it, it to the old specifications that needed a variance.
yes, so that yes, you're correct, so
In other
during
words,
the project.
in other words, this stuff you're saying, we changed it in the field, meaning that you just did what you wanted, your client then.
Yeah, that's what she said.
I just
Yes,
want to make that
yes,
clear.
they made the decision to, do
I
what they
find
would like
that
to do.
quite disturbing, just so you
Yeah,
know.
I think actually
I-
it does.
I
think
don't
Ms. Lowe does
disagree.
too.
Thank you.
I don't
All right.
disagree.
Me too.
Any other questions for the board? If not, do I have a motion?
Move the hearing be closed, the matter be placed on the decision calendar. Ms. Lowe, you'll be notified by mail of the board's decision once it's read.
Second?
Thank you.
All in favor?
Aye.
Any opposed?
Next, we have case 44325, Lido Beach, Richard Rubin, Special exception to install a shed with outdoor shower attached thereto higher and larger and exceeds horizontal maximum not permitted in the side yard, also known as 86 Sands Court.
Good morning. My name is Dean Kutsubis. My address is 121 Newbridge Road, Hicksville, New York, 11801.
My name is Ann Rubin, 86 Sands Court, Lido Beach, New York, 11561.
Good morning, members of the board. I'm here today with my client, Ann Rubin, of 86 Sands Court in...
Mr. Kitsuba, pull it closer and talk louder, please. I
Okay.
can barely hear you.
Okay.
We have paper show.
Sorry. Okay, so I'm here this morning with Ms. Ann Rubin, the owner of the property located at 86 Sands Court in Lido Beach. We're seeking a few variances in connection with the proposed prefabricated Amish-style shed and attached outdoor dwelling. Speaking to my client and speaking to the town, we found out that there was recently some pushback from the neighbor most affected. One change which I'd like to propose, and I spoke to my client about this, is we are willing to move this shed. So instead of a 2-foot setback, we're going to request that it changes to 5 feet setback. So just to give a little bit more space between the property line and our proposed shed and possibly mitigate some of the neighbors' concerns.
Okay, so the two parts of the shed that are proposed at 2 feet will be how far?
They would be 5 feet, and I would also just like to point out, we weren't asking for a side yard variance. That wasn't one of the variances, but that's just something that I feel may address partially or may help some of the neighbor
Yeah,
concerns.
you weren't looking for the size of the side yard, but you were looking for the special exception to put it in the side.
In the side yard, yes. So I feel that, speaking to my client, looking at the site plan, they have the space to do it. The shed is not built yet, so having that additional, having 5 feet is better than having 2 feet. So with that said, I would like to present the rest of the actual variances that we are requesting.
Okay.
All right, so we have the shed size. The proposed shed dimensions are 12 feet by 18 feet. The code maximum is a 12-foot horizontal, and we're asking for variance relief for exceeding the horizontal maximum. It is 10 feet tall, where
10.
10 feet tall where the code allows for a 9-foot shed. Again, that's a very small difference, and from my experience, sheds of that size and that height have been previously approved by this board.
Can you give us the overall size?
Yes,
you know,
the overall size, the shed itself is 216 square feet. The outdoor shower is 17.3 square feet, and it's a total of 233 square feet, where the maximum allowable is 144. This is a increase of 89.3 square feet over the allowable.
Any photos?
And the other variance that we're asking for is to have the location in the side yard of the property instead of the rear yard. And, I'd like to just present some reasons why we chose this location. This shed is the final phase of a multi-year renovation project that has included a second-story addition, in-ground pool, hardscaping, landscaping, various home improvements. The shed is essential for outdoor storage of pool supplies, seasonal outdoor furniture, bicycles, yard equipment, snow blowers, and other outdoor storage needs. While the home does have an attached garage, the family uses a garage to park their vehicles due to the harsh and salty sea air environment, which is common in this area, especially being on Lido Beach, to protect their cars. And also, I'd like to point out that the house lacks a basement, and thus further limiting the availability of storage space. The slight increase of from 9 feet to 10 feet is necessary to allow for an aesthetically pleasing roof pitch, and the increased size is really important just for that additional storage space which is necessary. The reason, another reason we're asking for the side yard is, although there's a sizable rear yard, the property is of pie-shaped nature, and the lot makes a side yard more practical and efficient location. The side yard is unusually large due to this pie-shaped lot, and having it there preserves more open space and yard space in the rear yard. It allows for easier access from both the house and the driveway, and takes advantage of space which is otherwise would serve any limited use or purpose. In concern to the neighbor, prior to filing this application, my clients had conversations with the neighbor about this proposed shed. At that time, which was several months ago, they had no objection to this. This is specifically the Josephs located at 87 Sands Court. At that time, they provided verbal confirmation that they had no objections to this proposed shed. And unfortunately, more recently, subsequently, it appears that they have changed their mind. They submitted, a list of concerns, which hopefully we could address some of these concerns, and hopefully we addressed partially by agreeing to move it further. I'd also like to point out that this proposed shed location will be located opposite the neighbor's own utility area, an area where they currently have their pool equipment, their garbage cans, their air conditioning unit.
Wait, Mr. Katsubis. So, I'm reading their complaint here.
Yes.
So you just mentioned that your proposed structure is opposite something of theirs. What are you referring to basically right adjacent to this proposed site? And what is it?
Correct. The neighbors have a fenced-off area which has their utilities, their pool equipment, their air conditioners, their garbage cans.
Is that what's right next to this?
That's on directly opposite the fence of where the shed will go. And I do have an aerial photo which I will show. Let me just finish here.
But I think it would be more helpful for us to have the photo while we're listening.
Okay.
Yeah.
At least for me.
You want to submit that?
All right, I'd like to submit an aerial photo highlighting the location of the proposed shed, showing the proximity to the neighbor's yard and the fenced-off area, which is there.
Where'd you get it?
I got that photo from Bing Maps.
What is it?
Bing Maps.
Bing.
Bing. It's,
Okay. Are you the one who downloaded it?
yes.
And ask them if it's fairly inaccurate.
Right.
You believe it fairly inaccurate.
And I chose Bing over Google because Google Photo was outdated. Being that there was a major construction done to my client's home, the Google Photo did not reflect that, so the Bing photo showed it.
There's pool back here.
And is it that somewhat triangular area on the neighbor's property that you're telling us has this equipment in it?
Yes, so the neighbor, so where we have when you see the red outline, the neighbor has their neighbor's utility area. It's fenced off from the rest of their backyard. Speaking to my clients, the neighbor has no windows on that side as well. So therefore, that also mitigates any concern from the neighbors. And to further mitigate any visual impact, my client has already planted a row of trees along the shared property line, which will serve as a natural screen in addition to the 6-foot-high fence. And as instructed by the building inspector, they are aware that a permit is required for the living fence, and they will file the permit for the living fence accordingly. Given the needs for practical storage, the unique lot configuration, minimal impact to the neighbors, and aesthetic care taken when designing this location and landscaping, we believe that the variances requested here are reasonable and not substantial. We respectfully request that the board grants these approval to allow the final component of the renovation to be completed. At this time, my client would also like to add a few words.
Okay, before your client speaks, I'd just like to go through this fairly lengthy complaint from the neighbors, which I assume are the neighbors you referred to earlier. So, it's 3 pages long. I'm going to summarize the basic principles. The first one is the impact on aesthetics and the character of the neighborhood. I'm looking at this Bing photo. I've listened to your testimony. It looks to me like many of the neighbors have many things in their backyards. Pools, hot tubs, equipment. So that's that. The next thing is a privacy concern that is said to be that the neighbors, one or more neighbors, may be exposed to someone showering. I've looked at the materials. It's clear that the shower area is enclosed. I know it's very small. I live in the Lido Beach neighborhood. Most houses have an outdoor shower. Next, there is a potential apparently for blocking sunlight and airflow for the neighboring properties. I feel as if that's the case, then they're all doing it, because it does appear to me to be consistent with the character of the neighborhood. There's a claim that there might be potential runoff that exacerbates drainage. We'll take that for whatever it's worth. There's an argument that it sets a bad precedent. It appears to me by looking at the neighborhood that the precedent's pretty much there for pools, pool equipment, sheds, and et cetera. Then there is a claim, which I think is maybe forming the heart of the matter. The claim is that the neighbors weren't entirely forthcoming about, that the neighbors have been doing construction for 4+ years of some sort, weren't entirely forthcoming with the scope of the, intended work along the way. Anger that some nice trees were in the neighbor's yard were cut down by the neighbor. In the applicant's yard were cut down by the applicant. And then a somewhat lengthy paragraph about the basketball court and the noise it creates. There's reference to a light over the basketball court that was 15 feet tall, and apparently one time was inadvertently left on for 3 days. After complaining, apparently the applicant changed it to a 10-foot light, which they still want taken down because it's bright, and maybe it appears they're kind of arguing that it might shine into the yard at times. As it relates to that light, I still have some things to go through. Is the light set up in such a way as to not infringe on the neighbors?
So the light is on the corner of the patio where the basketball hoop sits, and it's on like a minute timer kind of thing.
Okay.
And it's aimed this way towards the court,
Away from their house?
Correct.
Okay.
And
Can you please check and make sure that...
it's currently down, because when they first let me know that the pole was high, we were away. I said, okay, they put the wrong size pole in. I had it addressed immediately. We put the correct shorter pole in. Then we were away again, and she said, the pole is, I don't like this, it's not okay. So I said, okay, we come back later in the week. I will address it when I get back. We got back Wednesday night. The code enforcement person was at my house Thursday morning before I even had a chance to deal with it. He saw it, he said it was legal. I told the neighbor, I will take it down until the trees grow a little bit taller so that it will not disturb you. So it's currently down and in my garage. It's not even up.
Okay, when it's reinstalled, will you please make sure that it complies with all the ordinance, and do your best to ensure that when it's on, I get there might be over light just because that area is lit, but we don't want it shining.
No, it's very much,
Okay.
everything is
Okay.
angled away.
So the basketball court noise, and we've seen this before, and the trees seem to be an issue, and not telling them about the scope of the work, which apparently has been going on for quite some time. Then there's some general remarks that we see often, like, there might be noise, there's potential for noise, there's potential for this stuff, which we can't really, other than the stuff that we can really ascertain is happening, or, a 100-foot flagpole, we can pretty much figure that that's a problem. But general allegations that maybe one day there's noise or stuff is kind of hard for us to quantify. So I just wanted to go through the matters raised in that and let you, when you speak, to the extent you wish to address any of these further issues, feel free to do so. That's why I wanted to do it ahead of you.
I have a question then. The basketball hoop is on a pole, is that anchored into concrete?
The pole is, but the hoop part comes off.
Do we not need a permit for that?
Okay, we can absolutely address that and get that taken care of.
One other thing I forgot in the complaint, something about having built a 3-story deck. Let me see, a 3-story, they were mad also that you apparently put a new foundation under, and there was something about changing your siding, et cetera, but there was mention made, I thought I noted it. Can you just explain that they think you have a 3-story deck, I think it was?
Well, I guess technically it's 3-story because you have the ground floor patio, which is now covered with a deck off of our master, and then a small 3rd story so we can see the ocean. It was all permitted and done with structural engineers, architect. The town approved it.
Okay, keep going then. Tell us whatever else you want to tell us now.
Okay. So just a little bit. I'm a 3rd-generation person on the barrier island. My grandparents lived on the island. My parents built our first house in Lido Beach down the block. When my father passed away, my mother remarried, she bought this house. When my mother passed away, I bought the house. We have no intentions of ever giving up this house. My children tease each other and fight about who will get the house. We did all of this work with the intention of this is the house for our children to be in, our grandchildren to be in, and we're not going anywhere. The house that the Josephs are in, I've been in this house almost 40 years. That house has turned over 3 times since I've been there. Everything we've done has been done with a lot of care for long term, and this is a family home. The construction went on for a significant amount of time because the original contractor we hired did shoddy work, and we brought in another contractor to fix it. And when we brought the second contractor in to fix the work, we found that not only did he not do proper work, but he endangered the structure of the house and had created, we had no damage during Sandy, which, as you guys know, in Lido Beach is unbelievable. Our crawl space had been dry. The patio he put in, what's the word I'm looking for, compromised our foundation, and we were leaking into our crawl space. So I understand the construction went on a very long time. I was in communication with the neighbors, letting them know the situation, letting them know what was going on, that, we now had to replace the sill plates on our foundation. We had to add structural beams back into the house because he removed things he shouldn't remove. We had to redo the deck. We had to add in, for drainage, what are they called? The big dry well. We had to add in dry wells. The pool had to be redug because and rebuilt. Right, the pool had to be redug because it wasn't done properly. So we've incurred significant expense on top of significant time to redo poor construction. I was in communication with the neighbors at all times. Anytime anything was brought to my attention, it was addressed immediately. I know a dumpster was placed slightly over one day in the street. I called, we had the dumpster moved immediately to our, moved over and put in our driveway immediately. When the neighbor brought up the concern about dust on her car, I told her to please take it to a particular body shop that we work with, and I would happily pay for her car to be detailed, clay barred, whatever needed to be done. She never did that. I've always been very transparent and let them know what's going on. The trees we took down because frankly, my mother had, you know, a forest back there, and we knew we were putting in a pool. We put the pool in. We've since replanted trees, like Dean said. You know, we want to put our cars in the garage, so we need the shed to put everything else in to maintain it. Like, you know, we're trying to be good neighbors. I've been there for years. I communicate with everybody. I let everybody know when we're having people over, when my kids have people over. I make sure that, you know, 10 o'clock at night during the week, 10 o'clock on the weekends, I make sure they're not loud. You know, I'm a longtime resident. I could tell you the history of Lido Beach. I could tell you who's lived in every house. I could tell you Long Beach. We just want a nice home.
Just one thing regarding the drainage. I understand that the neighbor had a concern about drainage. I do feel that, you know, by us voluntarily moving it that extra, you know, feet, you know, that extra, so we have 5 feet, that'll provide more space. So any roof runoff from this shed could land on my client's property. Everything else, so as far as the drainage, looking at the aerial photos, the paved surfaces, there's grass all the way around every surface, so there's no chance of water running off from my client's property and any neighbor's property. Even looking at the aerial photo, I do see some of the neighbor's properties have pavers right up to the property line, so
We see that.
that's been addressed.
Mr. Katsubis, I'm sure you're aware of the fact that in many instances, one or more of the board members will go out and inspect the premises. And do you have a dog, ma'am?
Yes, we do.
A large dog or a?
Yes, but he's not outside unless we're outside.
Okay, so one or more of the board members may come down to take a look. We'll ring the bell first and let you know we're there, so we can avoid any calamities.
That's not
Mr.
a
Katsubis, when we go to deliberate on this matter, we're going to deliberate on the 5-foot, so we're going to need you to amend that plot plan and get it into the zoning board so that that's what we're deliberating on,
Correct.
okay?
And you're aware that there are a number of open building permits, and I assume
Yes.
they'll be closed out?
Yes, sir. So because we had to redo everything, we've taken a lot longer, and we are currently waiting for the electrical underwriter to come. The electrician has called for all of those inspections, and from what I understand, we're on his list and just waiting for him to come, and once he
Okay.
comes, then we can call for our final inspections.
Okay, any other questions from the board? Go right ahead.
Hi, it seemed a pretty lengthy bit of complaints about the construction over the years. So my question to you is that primarily from Joseph David?
It's all one
What
person.
about Matthew Roth? They live next door. Langston, there's a bunch of people. You have a court, I see. You live in a court? Has anybody else voiced concerns about?
No.
So from your point of view, it's just them?
Yes, sir.
Thank-
And from the records, it's only them.
It's only them.
Good point.
I was just curious, because if there's, all this is happening, you know, I wanted to know
I
what
think
the
you
other
make a
neighbors
good
thought.
point, Mr. Pump. I really do.
Thank you, Mrs. D'Amato.
Thank you both.
So I move that the hearing be closed, the matter be placed on the decision calendar. Mr. Katsubis, you and your client, Ms. Rubin, you'll be notified by mail of the board's decision once it's ready.
Second?
Second.
All in favor?
Aye.
Any opposed?
Me?
We're done. You can clean up.
Thank you.
That's nice of you to say. Do you think he was going? Talking about a phone number. What? What? She's questioning about that phone number.
Next, we have case 44425 through 44525, West Hempstead, Islam Muhammad. Variances, lot area occupied, front yard setback on Edward Court, rear yard, construct second-story additions and portico, all attached dwelling, maintain 3-foot high fence on 1-foot high curb totaling 4 feet high, which may obstruct line of sight at neighbor's driveway, maintain living fence forward dwelling on Edward Court, varying in height from 3 foot to 6 feet high, also known as 166 Edward Court.
Good morning once again. My name is Dean Katsubis. My address is 121 Newbridge Road, Hicksville, New York, 11801.
My name is Helen Bogdanos. I'm a structural engineer. I'm the architect of the record of this particular job. My address is 121 Newbridge Road, Hicksville, New York, 11801.
Good morning once again, members of the board. We are seeking variances for a proposed second-story addition over the existing house breezeway and partially over the existing garage. This is in regards to 166 Edward Court in West Hempstead. The second floor will include 3 bedrooms, 2 bathrooms, and we're also proposing an front open portico over the front stoop. The proposed addition requires variances for not meeting the setback requirements of 25 feet for corner houses and a rear yard setback of 25 feet. We're also asking for a lot coverage variance. The setbacks are as follows. We're asking for 12.7 feet to the front yard. That's to the closest point along Edward Court. That's for the second-story addition. We're asking for 9.9 feet to the portico, and we're asking for 5 feet rear yard. And that's our more substantial one, to where that's to the 5 feet to the rear yard, where 25 feet is required.
Mr. Katsubis, it's a corner lot? What's the required front yard?
It's a corner lot, so the required front yard is 25 feet, and we're asking for 12.7 to the closest point. We do not need a front yard variance towards Coolidge, as the second floor does not extend all the way to the edge of the house that direction. It only partially goes over the existing.
No portion of the proposed second level is outside of the footprint, correct?
Correct, so that we are going straight up from the existing footprint. The only encroachment outside of the footprint is the proposed portico. We are also asking for a lot coverage variance of 37.6%, where the requirement is 27.5. Now, that may seem substantial, but the only increase to lot coverage is the portico, which is only 31 square feet. It's essentially 3.83 by 8.25, so it's a very small open portico just to cover the existing stoop, and that's the only increase to lot coverage.
Mr. Katsubis, you said that the front yard, I believe you said on Edward, you're proposing the closest point to be 12.7, where 25 is required.
Yes.
But in looking at your materials, I don't know if you're calling it a plot plan or a site plan, but either way, it's the same document. It says that the proposed front yard on Edward is 9.9, and that's no change, and the proposed front on Edward Street versus Edward Court, I'm sorry, is 22.9 and no change. So the grid on your materials says there'll be no change, and again, Edward Court is 9.9, Edward Street, also known apparently as Coolidge Street, is 22.9. So I don't even have a 12.7 as a
The 12.7 is, if you, looking at the plot plan,
I see it.
all the way to the, all the way to the left is the 12.7.
I see
That's
that.
the closest point, and it gets bigger from there. Along Coolidge or Edward Street, our second floor is not extending all the way to that 22.9 setback. It's set back another 8 feet, so we're not asking for a variance in that direction.
So that 12.7, which looks like it relates to the front wall on the first floor,
Correct.
is not in fact the first wall. It pertains to that part of the second floor that's set in a bit, or?
No, it's not gonna be set in again, it's gonna be flush. So the existing
Oh, 'cause it-
setback is 12.7, and we're going straight up, and it will remain 12.7.
So why do I have 9.9 on your
The
sheet?
9.9 is to the portico.
So the existing, and the portico is not a permitted encroachment?
It is permitted, but not, it is permitted, but not, not to that extent. So if we're allowed 25 feet with a 6-foot encroachment, we're only allowed 19 feet, and we're asking for 9.9.
So actually what you're telling us is that the second, as you said, the second floor construction proposed is within the footprint, and in fact, the current footprint, or the current setback on Edward Court is 9.9 because of the fact that only a portion of your portico's permitted encroachment, and you just are otherwise gonna do the second floor at the 12.7 that currently exist on the first floor.
Correct. And the same, I'd just like to point out, the rear yard here is that's, the technical town of Hempstead code required rear yard is that 5.2 feet, which is all the way on the south end of the property, that we're going straight up from there. So that's our rear yard, it's supposed to be 25 feet. It exists as 5 feet, and we're proposing to go in line with that at 5 feet.
Would you pull the microphone a little closer, please?
Sorry.
Is the platform on the back that has it's not clear, maybe a 2.1
So-
setback, is that?
Let me talk to you about that.
My question is, does that need relief here?
That does not need relief here. That was actually original to the house. We did pull the plans from the original construction. The house was built in 1953. It was built with a variance in 1953 for the construction of the house, and that rear stoop and outside entrance was part of those approved plans and survey from the 1953 plans.
So, Ms. First, have you seen, is that otherwise legally there? It's not in our equation as it relates to our rear yard analysis?
The original house was built
5070
in
says, 53.
1953, under a variance. Let me just look at the plot plan quick. You just need to give me a moment so I could just check the plans to see if they match.
How high is that platform, Mr. Katsubas?
It goes up to the first floor of the house. It's really only like 4 steps up. You see steps going in 2 directions because one step goes up and one stair goes down. So it's even with the first floor. It's only to provide access.
One step goes up and
Well,
one step goes down.
Well, if you're looking at this platform, there's steps to the left and to the right.
Correct.
The ones.
I'm just guessing that the ones that go up also go down.
No, the ones, from ground level, you go up 3 risers to the first floor, and from ground level, you go down 6 or 7 risers to the basement level. So it is
Oh, there's an
combination.
exterior cellar entrance?
Yeah, all on the original, plans, originally survey, just the way you see it here. So we, okay. I have not, Mrs. Bogdanos has been in the house.
So the rear yard measure that you're using here, you gave us the 5 feet. So that's referring to the edge of the corner of the house that is, let's see, south of that platform on the back.
Correct. The platform is located in the side yard, not the rear yard.
Oh, that's your side yard back there?
That's our side.
Well, then how is that your rear yard measure for the variance?
It really
Because
should be
You
five.
have a corner, right?
It's a
So you
corner.
have one side yard, one rear yard. You're telling me that the rear yard in this case is the south side of the house?
Correct. The
So the
5-foot,
variant,
5-foot side yard complies.
hold on, so the distance from the house to the property line on that side is 5.2.
5.2, yes.
So the rear yard is 5.2,
Correct,
not 5, which is the other side.
correct.
Well, your thing has, where's the? So it's,
Yeah.
but see, you have it all on here as that being the side yard. I mean, we just have to get the numbers arranged. You see, the south side of the house in your grid is 5.2 and the side yard.
That looks like it may have been an error. Clearly 5.2 is the rear yard, and
Well, I don't know
5.0.
how clearly that is, but in that case, your side yard, if you're making the west side of the house the side yard, Becky, can you help with this? You see what I'm,
Good idea.
but
Thank you.
he's referring, for his variances requests, as the west side of the house being the, let's see, rear, the side yard, no, I apologize, the rear yard. He's doing it both ways, on what's rear and what's side. We gotta clarify this.
I mean, correct. I acknowledge there could have been a mistake on the grid, but from my experience on a corner property, the narrower frontage is the primary front, and opposite that is, there's also another portion of our application, if we could talk about it. There's a living fence, there's a fence and a living fence which needs a
Really,
variance.
understood.
And I do have, some pictures here of this condition.
And you did take them,
Okay, all right, so, Mrs. Bogdanos took these photos, and I'll just like to submit to show that the trees are far from the intersection, thus not providing line of sight issue.
Mrs. Bogdanis, you took those photographs. When did you take them?
I filed them with the whole package of the variance.
When did you?
2 months ago.
You took them a few months ago. And do they fairly and accurately represent what they purport to represent?
Yes.
Okay.
They
We'll
asked,
accept them in evidence.
so I went personally and I put the
So did I, and so did one of the other board members.
All right, I'd just like to point out that the house is, the way the house is situated, it does not provide any outdoor yard space for the family to use. If you look at it, there really is no backyard in this house. Having these trees here enclose a portion of the grass is necessary to provide screening and create this outside area for the family to use. The trees are located in the front yard along Edward Court, and they are 20 feet away from Edward Street or the corner, thus creating this clear sight triangle, and it does not block any line of sight. And it does not, there's also a chain link fence which does extend up to Edward Street. That chain link fence is see-through and does not block any visibility to any of the neighbors.
Mr. Kasulis, one of the pieces of relief is the fence that's 3 feet tall that's on top of a 1-foot curb. Is that fence see-through or solid?
That's a see-through fence. That's the one that's, it is up against the neighbors. The neighbor does have their driveway there, but
Okay, hold on.
it is a see-through chain link fence.
Coolidge. Temporary. If we are inclined to approve that fence, we would be approving specifically that fence at that height, because it would not be a scenario where, and it would be a temporary grant, because we need to determine, we need it to stay open for the visibility. Can I just see, I didn't see the, I want to see the, I didn't see the curve under the fence. Looked like a 4-foot fence.
Back here. See?
Oh, I see.
Slants down.
That looks to me like a 4-foot chain link fence, not including the curb. You're sure that's a 3-foot chain link fence? Okay. Right, but you know, one of the issues is if you sell your house someday and a new guy
Somebody
comes in
else.
and goes, ooh, I want a 6-foot solid fence. Now, people can't see either vehicular or pedestrian traffic in and out of the drive. That's really why the issue exists. Understood.
We will.
It's a very difficult lot, the worst I've seen in my 35 years of experience.
What is it?
Very difficult, you know, corner, no backyard, no nothing.
Well, that's because the house is big, right?
It's not big, no, it's a small house.
With the garage it is.
The garage, yes.
Yeah, look, I understand there's not a lot of yard, but there's
Covers,
seemingly a lot.
covers a lot of ground.
Can you tell us what is in your basement? Did you already?
Yeah, we have the permit.
No, what's down there?
Open space, I have a plan.
I'm gonna finish it. There's a bathroom. No, she said open space. It's- Take a look. Partially finished.
Yes, okay, so there's a basement, there is a bathroom, a utility room, and everything else is just open finished cellar.
How many kitchens are in the house? You've been throughout the house? Because it looks,
3 times, it was difficult,
There's
so I
two-
have to go myself.
there's 2 front doors to the house.
Yeah, they have it as a second door, but there's no kitchen.
Well, then it's weird that the second door with the doorbell also.
That's the way it's always built, but
Full bath, a closet, open space.
yes.
Is the second door that Mr. Pellegrini is referring to, is that door lead into the breezeway?
But there's no kitchen, no second.
Can I ask you related to the cellar? As you said, there's a full bath down there. There's a very large utility room segregated. Okay, and then there are 2 closets, and then in the large area, there is a long counter that looks like it would have been a kitchen counter. Was there ever how long have you owned the house?
She didn't own it. She's not the owner.
Just to clarify, Ms. Bogdanos doesn't own the house.
I apologize. So, how long has your client owned the house? All right, let me do it differently. What's the counter for in the basement that looks like a kitchen counter?
It was there, I just moved while I was there. But there's no kitchen. I mean, you can call the inspector to go and check.
You can bet there's 220 down there. looks like the basement at one point was very likely an apartment because it has 1 or 2 bedrooms, a full bath, a kitchen area with a counter. Yes, the appliances are not drawn here, and, finished other space like, maybe before your clients owned it or something. Mr. Kitsubis, do your clients have children or?
Grown up children, they have two, they live with them. Grown up.
All right, so, I guess, let's hold it and move on so these other folks don't have to move on. Okay, yeah, so maybe just pop over there.
Yeah, we'll
and
call
as soon as
another
Patrick comes
case.
back with the other information, we'll finish up.
Okay, so next is case 446 of 25, Baldwin, Fritz Michel, special exception to maintain second accessory structure, enclosed roof over patio, higher than permitted and exceeding horizontal maximum on 2 sides, also known as 700J Way. Ms. Lo Chenise, we have you sworn in from before, so just your name and address for the record, please.
Well, good morning.
Good morning, long time no see.
Smiling face. Where the hell are the search sheets?
I just want to fix the materials.
How come there's no search sheet?
Joe, can I use your pen? Right on the official.
Oh, this is a Mark Anthony one.
Can I begin?
Yes.
Okay. Good morning again. My name is Ashley Locunis from Mark Anthony Architects. Our office is located at 1563 Belmore Avenue in Belmore, New York. I am here today representing for my client, Fritz Michel, who is the owner and occupant of the subject property located at 700 J Way in Baldwin, New York. We are before the board today as a result of an application filed with the building department under 24-7148, which was to maintain a semi-prefabricated enclosed roof over concrete patio. Our first variance request is to allow a second accessory structure on the property. There is an existing frame shed also located in the rear yard, so this roof over patio is the second accessory structure. Additionally, the width of the roof over is 12.85 feet, where only 12 feet is allowed, for which we are requesting just 0.85 feet of relief. And lastly, the height of the roof over is 10.88 feet, where the maximum height allowed is 9 feet, for which we require 1.88 feet of relief. There are no additional applications or requests before the board today, and all permits previously issued for the property have been closed out by the building department. Should this application be approved, this permit will be closed out at inspection. Those are our only requests today, and I'm happy to answer any questions.
There was a
at this
fence
time.
permit taken out in 2020, 13400, for a 6-foot-high vinyl fence. That's been closed.
10, 10 and a half, is that what she said?
Shows open on the search sheet.
Did you say the height was 10, 10 and a half?
10.88.
10.8.
Mr. Regano, I apologize. I read the search too quickly. There is a fence application opened, and I will make sure that it is
That will
closed
be
at the time
closed
of
out.
inspection. Thank you.
So the diagram says 10 feet, 10 and a half inches. Is that equal to 10.8?
Yes, it just translates to the decimal.
Well, then
It's
a half,
it's
yeah.
approximate, yes.
What are your clients going to use this shed for?
So do you guys have photos?
We do.
So the photos, when I was there, they were using it, there were plants in there and just backyard items. But when I was there, that was all that it was for, plants.
They seem to have windows in it. I'm just,
Yes, you could, if you could kind of see in the window that there are some plants on the windowsill as well. So I believe that the reason it's semi-prefabricated is because there was not a floor, so that's what they mean by semi-prefabricated. So the walls and the,
so it'll be used for storage, no lights, no electricity, no heat?
no electricity, no heat, no AC,
Okay.
nothing like that.
Any other questions from the board? Not, do I have a
Will
motion?
the hearing be closed, the matter be placed on the decision calendar? Ms. Lowe, you'll be notified by mail of the board's decision once it's rendered.
All in favor?
Aye.
Any opposed?
Thank you.
Welcome.
Next, we have case 44725 through 45225,
How did we
Levittown,
do? Wait a minute.
Stephen Rosalia. Special exception to maintain shed higher than permitted, special exception to maintain second accessory structure, gazebo with bar countertop, higher and larger than permitted and exceeding horizontal maximum on all sides, special exception to maintain third accessory structure, outdoor barbecue unit, exceeding horizontal maximum on both sides with less than required side yard setback, maintain pool equipment with less than required side yard setback, maintain 8-foot 2-inch high arbor, variance height, side yard, construct second story addition, portico, and install 2 AC units, all attached dwelling, existing second story to be demolished, also known as 56 Anvil Lane.
Good morning. Thank you for having me here this morning.
Thank you for
I'm
coming.
with the Architects 32 Design Studio and Atmosphere Design Group. We're here for 6 variance cases. The first 5 are for legalizations that we informed the owner he would...
Did you give,
Oh, I'm sorry, I should... Yeah, that's
Yeah.
a good idea. I
Yeah.
apologize. Lou Trentadue, 32 Design Studio, 133 Lincoln Avenue, Pelham. The zip code is 10803. Do you need me to spell my last name for you?
pardon?
Okay. I'm sorry. I'm representing the interest of Stephen Rosalia on 56 Anvil Lane, and he is in Levittown. I apologize. I just got too excited. Okay.
Excited? Excited?
I haven't slept in days. No.
Look at the live stream.
Excuse me?
Just look at the live stream. You won't be excited for long.
Oh, boy. Shall I proceed? Excuse me? I have other projects. I have a variance tomorrow in Southampton for a builder friend, and it wasn't supposed to get a variance, but sure enough, it needs one. So I got to go all the way out there at 6:30 tomorrow night, and I've been preparing for it as well as this one. And then I have something else in Mount Vernon. So I'm supposed to say it's good to be busy, I guess. So.
All right.
Okay, thank you. We were hired by the owner to initially design a second-story expansion on their dwelling. And upon our inspection of the property, which we started to work with the owner on in 2023, he gave us a new survey, and he was proud of the fact that he was ready to go. And we said, you know, we did a search sheet, and we realized there are several accessory structures on your property that don't have permits. Fortunately, the pool had a permit, but we worked with him to file separate applications for a shed, a backyard barbecue, a gazebo, also a sunroom, which didn't need a variance. There was also a fence that had to be moved because it was pool enclosures. For some reason, one of the fences was built outside of his property line. He addressed that. So we said to him, we can work with you for the variances after you get the main project going, because the building department needed to have those applications in so that they could proceed to approve his dwelling application. Unfortunately, the dwelling was built higher than the maximum allowable 30-foot height above the crown of the road, and the 2 AC units on that application were encroaching in the side yard. So what I'm going to do is I'm going to just briefly read through each case and say what we're seeking relief for and what we have existing. If that's okay, I'm going to try to do this as efficiently as possible. The first case, which is 447, is for the first of 3 accessory structures. It's for a shed, and the height of the shed is 10 feet, and that exceeds the maximum allowable of 9 feet. That's on the right side of the property. The second case that we're seeking relief for is coined as a gazebo. It's in the rear of the property. It exceeds the maximum allowable height of 9 feet because it's 11 feet 8 inches. It also exceeds the maximum left and right dimensions, being each 12 feet, because it's 14 foot 6 in one dimension and 24 foot 6 in the other.
Wait, 12.6 and 24.6?
14.6 and 24.6.
I apologize. Thank you.
And it's also the second accessory structure of 3. So it's being cited as part of a variance for that reason.
And the larger number, what's that?
Yeah, it's also going before the board because the area exceeds 144 square feet. It is 355.25 square feet. The third case we're here for is for a built-in barbecue unit that's fired by a propane removable tank, the typical kind, not a direct gas feed. That unit, it exceeds the maximum dimension of 12 feet in length because it's 13 foot 6. It also encroaches on the on the left side of the property. It's supposed to be 2 foot setback. It's unfortunately 1.7 feet. And this also counts as the third of the 3 accessory structures that we're here for today. The fourth case is for a pool heater that is electric. It's not a gas-fired pool heater. This has a setback of 4 feet from the rear and sides. It is 2.6 feet from the right side property line, so that's why we're here for that case. And the fifth variance we're seeking is for a fence arbor, the arch-like condition trellis that you see on the left side of the property in the front. This exceeds the maximum allowable height of 6 feet because it is 8'2". We didn't think that this needed a variance initially, but it was picked up upon that it wasn't part of the enclosures that was granted with the permit for the pool, so we had to separately file a permit for that, and that's one of the reasons we're here before the board today. The sixth and final case is case 452. That's for the dwelling itself. The 2 AC units were in a different location on the approved plans that would have met a 5-foot setback or greater. The builder and his mechanical his mechanical contractor, they put the AC units on the right side of the property, and they did not realize that they needed 5-foot setbacks for that, and they are set back approximately 3 feet. In addition, the final reason we're here today is because the ridge height, which was specified to be 30 feet or less from the crown of the road, the builder didn't realize that that meant from the crown of the road, not the average grade. So he built the roof. Unfortunately, it is at a height that is 31.63 feet above the crown of the road. So it's a variance request of 1.63 feet above the 30 feet.
He built it?
Yeah, that was the proposed work project.
This is a construct request.
Excuse me?
The request is for height to construct a second-story addition. Is it already there?
What was your question?
So it sounded when you said he built the roof, a certain thing, that it was already constructed,
Oh,
where
no,
the
I'm
variance
sorry.
before us is to construct it.
I'll clarify that. The permit was approved for the second-story addition, and it was slated on the plans to be a 30-foot or less height above the crown of the road. That permit was approved and granted. They proceeded to build the structure. And then when we said to the owner, okay, we're ready to move forward with our variances for the accessory structure, let's update your survey. He got the updated survey, and it came back on the survey that the ridge height was now over 30 feet above the crown of the road.
On the second story?
Yeah. It's 1.63 feet. It's about, I would say that's about 19 inches.
This was the original.
Yes. I wanted to be polite and not throw the book at him on that.
Is the second story that's there now going to be demolished?
I'm sorry?
On here we have maintain feet 2-inch high arm, okay.
Yes.
Construct second-story addition, portico, and install 2 AC units all attached to dwelling. And then in parentheses, it says, existing second story to be demolished.
That's correct.
So you're going to demolish the second story that's there
Right.
and put a new second story on.
That was what was part of the proposed work that was done in 2023 and 24. They removed the existing second story, and they erected a new second story. The reason why the existing second story was removed, because it didn't have adequate attic space. It didn't include it just wasn't laid out correctly. So the owner wanted to improve the appearance of the home, so we redesigned it.
This is already a building permit, and a supplement was filed for a height request.
Oh, it is already built?
Yes, it was already built, it was issued a
So
building
it's not a
permit.
construct?
No, it's a maintain.
Okay, so we'll have to change that. But wait.
Yeah, I'm sorry.
Looking at the elevations, so I'm looking at the front elevations, A4, and it says the average crown elevation 55.65. Then it shows from that 23 feet to the ridge.
Okay, I'm sorry, you're looking at the front elevation of the,
A4. I mean,
do you need me to approach so I can see what you're looking at too?
sure.
Thank you.
No, you're looking at the wrong plans. This is the Edward Courthouse.
Okay. I saw the photos and I thought that must be the
That's-
picture of the,
no.
I thought it was
We're
the,
we're back
she
on
spoke
Edward.
to you about the, tearing it off, so that's why I thought it looked different than the.
It does, because it's a different house.
Well, okay, further. But we definitely have to amend this caption, Christina. Yes. Was that the old house? Look.
So, after review of the plans, we found that additional information is going to be required to properly assess the application, so that cases 447 through 452 of 2025 will be adjourned. Patrick, can we have a date?
October 1st?
No, I can't. I have another hearing scheduled. Would we be able to come on the 15th? I'm going to be traveling on that weekend.
Sure.
Of October, excuse me.
Yeah.
Sure. October 15th at 11 a.m.?
Is that okay, Patrick?
Yes, sir.
Okay.
All right. October 15th, 11 a.m., partial testimony taken. Okay.
Okay, all right, thank you.
You'll speak with
See you in
Ms.
October.
First and see what's going to be required. All right. Let us, we're going to return to to Mrs. D'Amato's favorite case,
Yes.
because she's looked at those plans 12 different times.
Kasubis's case.
Is there anybody still here on that case?
Yeah, we're,
Okay. I hate to give this back.
I don't have any material, but I'll just.
1 minute. Promise of 1 minute.
And I don't think there's any other testimony we need to hear from them, right?
Yeah.
All right, Patrick, let's just
Edward
recall
Court,
that.
Edward Street. Wait.
Patrick, can you just say the case number? You don't have to go, everything.
This is a continuation of cases 444 and 445 of 2025, Aslam Mohammed.
Okay, Mr. Katsubis, members of the board were able to look up, and your understanding of where things were, I don't have them in front of me, but the papers were accurate as to what was rear and side yard, okay? So they were flipped. But either way, the papers are correct. I think we have all the testimony we need. I don't know if there's anything else. And she can go by the papers instead of the transcript as to what's rear and side. Other than that, is there anything else you wish to add?
I feel we covered everything. We talked about the fence, we talked about the addition. We're going straight up. There's no further encroachments other than the portico, unless, Ellen.
Okay,
We
good.
actually, just one other thing, we did contact the client while we were in the hallway. They did own the house since 1994. There was no kitchen when they bought the house. There's no kitchen today.
Thank you for doing that.
So we confirmed
Ju-
that.
Just, okay, one original observation. Your front portico is open,
Yes, it's
and
open.
your client will agree to a condition that it remain open and not be enclosed in the future. Is that correct?
Correct.
Okay. All right. Any other questions from the board?
Move the hearing be closed, the matter be placed on the decision calendar. Mr. Katsubis, you and your client or your architect will be notified by mail of the board's decision once it's ready.
Second, all in favor?
Aye.
Any opposed? Any abstentions?
Thank you.
Mr. Chairman? Would you like to do the second call of the case from this morning?
Oh, yeah.
Which case was that?
One of them.
The renewal?
236?
436?
436. All right, so call it.
Second call, case 436-25, Baldwin, Gladys Beltran, and Fanny Velasco. Renewal of grant to maintain two-family dwelling, also known as 479 Emerson Avenue.
Is there anyone here on this case? Okay, so this is a renewal. It is a... Oh, go ahead. Are you here on this case?
Next case.
Okay. All right, so this is a renewal of a grant to maintain a two-family dwelling. The applicant did not ask for an appearance waiver, but we're going to grant one anyway. And the building department inspected the premises on April 24th and found that all conditions previously imposed by the board are being complied with. Do I have any other questions from the board? If not, do I have a
Move the
motion?
hearing be closed, the matter be placed on the decision calendar. The applicant will be notified by mail of the board's decision once it's ready.
Second, all in favor?
Aye.
Any opposed? All right, so we are now going to take a short break before we start calling the 11 o'clock calendar. Yeah, and they're both renewals. 3:30, three of them. Two 7-Elevens and a Uniondale. Yeah, now, do we have any, were these inspected? It's renewal of a grant. Do we have? Okay, so when, 3:31, when was that inspected? It's gonna be
I also have to
2.5
check, yes,
seconds.
and I already did this.
4:23?
Yeah, but this must have come before us before. Does it say that?
Renewal of a grant.
Because I circled them on that day. Oh, that is a order to appear.
Yeah. And what about this? OTA, OTA, all three.
Here, but I don't know if it's the same guy, but he's here.
All right, when was this? When was 332 inspected?
429, again, it wasn't heard because look, John, look.
I got it, but it's a renewal.
When I circled them in advance, that means it's been before us before.
Okay, and when was
429,
when was 333?
429.
Why did we issue an order to appear, just because they're commercial cases?
I'm not sure, there must be more than that.
All right.
So 423. these to Patrick, because he's, so that also means I'm gonna quit oscillating. You what? I love Peter. It is so bad. Kim, you can, since John's not here, stop it from oscillating, and it'll be straight at you.
Why don't we open the doors for the outside?
I should have bought more of them, shouldn't I?
First, we have case 33125, Uniondale, McDonald's Restaurant, renewal of grant to maintain one double-face illuminated ground sign, overall size 100 square feet, overall height 20 feet, also known as 1050 Front Street.
Loudly. Louder.
My name is Josh Kaufman. I am the owner of the McDonald's at 1050 Front Street in Uniondale. My home address is 3 Woodvale Lane, Huntington, New York, 11743.
Good morning.
Hello.
Yeah. So you're here for the renewal of the one double-face illuminated ground sign. The building department inspected the premises on April 23rd and found that you were in compliance with all the previously imposed conditions. Is there anything you wish to add?
No, we've had this McDonald's location there since 2008. We purchased it, but it's been there even before that, and we've always tried to be in compliance, and we thank you for all your support.
All right, if there are no further questions from the board, may I have a motion, please? Second, all in favor? Terrific. Have a
Thank
nice
you.
day.
Have a good day, everyone.
Next, we have case 33225, Wantagh 7-Eleven Incorporated, number 18991, renewal of grant to maintain setbacks 1 foot from Beach Street and 1 foot from Park Avenue for one double-face illuminated ground sign, also known as 3382 Park Avenue.
This guy still didn't show up.
Morning, my name is Michael Wink. I reside at 949 South Long Beach Avenue, Freeport, New York, 11520.
Good morning.
Good morning.
You're here similarly to have your grant for your one double-face illuminated ground sign in Wantagh renewed. Is there anything, building department inspected on April 29th, found you to be in compliance with all the previous imposed conditions. Is there anything else you wish to add?
No, just that.
What is your relationship to the 7-Eleven?
I'm a district manager
For just this one or several?
for 7-Eleven, so I run 13 stores from Merrick to Lindenhurst.
Do you run the Oceanside store?
No, I don't.
Okay. Okay.
I know there was 2 cases, I heard.
Okay.
I represent the other one.
There's several cases, 7-Elevens that we've had that no one has showed up.
I apologize for that. So I just took this district over about a month ago. And some of those emails intertwined with the last district manager, so I guess there wasn't representation. I got this from our legal department saying that you're not in compliance, you guys didn't appear. Had I known, I would have been here, but.
Sure,
Okay.
But consult with Patrick, he's the secretary to the board, and he kind of he'll send out the notices for the renewals on 7-Eleven. There's a couple of them that are hanging out. You might want to.
Yeah, well, maybe we'll intertwine after after this, just to see, because there's some stores that I run, other stores I don't. It's a different district manager, so I'm not responsible for those. I'm only here for the one I'm responsible for.
Thank you.
Okay, any other questions from the board? If not, do I have a motion? Second. All in favor? Have a nice day, sir.
Thank you very much, appreciate it.
Okay.
Yeah.
Unrelated to your application. I go to 7-Eleven all the time, different stores. Sometimes I get very nice cloth bags,
Mhm.
and sometimes I get paper bags that are greater than like 2 seconds. Does each franchise purchase them on their own?
So it's different. So if you're in a corporate store, it's provided by 7-Eleven. If you're in a franchise store, that's different because it's a cost of goods thing. So they operate their own locations, and certain things they purchase for the store is their expense. So you'll get the
So
point
the
you just made.
franchise agreement doesn't require them to get their bags from corporate, I guess?
No.
If they're allowed to freelance it?
As long as it's within regulation with, the plastic bag thing that we have going on, they can purchase on their own, yep.
Okay.
You're welcome. And you'll see the difference. So when you go to, anybody else here? So when you go to a corporate store, it's different than franchise. Meaning when you walk into some stores and there's things that are on sale and the associates are friendly, like that's with corporate. Franchise is different because they run their own.
Yeah, they try to run a scam and not give you the sale price that's nationally advertised.
That's what I maintain. So I make sure that.
Subway does that a lot near my house.
I make sure that they're within contractual obligations as far as purchasing goes. But you'll run into stores, like if you walk in the back aisle by where we have like all beer and soda and things like that, you see those aisles are empty in the back. That's a franchise store. So
And they always a lot of them stack all their stuff in the halls everywhere, so it's all dumpy looking.
yeah. And listen, I try to help them with that as well, especially franchise owners, because you have to your inventory levels have to be in stock, right? Because when you have orders that come in, two things happen. One, you either overstock the shelf, and it looks a mess, or you got to put it in the back, and then in the end, you wind up writing it off, where it's a loss for them. So we try to maintain those inventory levels and sequencing and things like that, so that when orders come in, it's a little bit more advantageous for them. And it doesn't take, they talk about labor hours and things like that. If your store is not in stock or you have too much stuff, you can spend labor hours to put that away. Quite honestly, if you're in stock and your levels are correct, you don't have to worry about those labor hours. So some of the things that we're working on.
Maybe you should make surprise visits.
Pop-ins, I do. I'm retired from the police department, so I always pop in. So.
Okay, all good? Have a night.
Appreciate it. Thank you very much.
No more questions.
Don't leave yet. Maybe he could do this.
He doesn't have it, I already asked him.
I know, but maybe he would want to do it.
No, he doesn't have that case.
I know it.
The Oceanside store is not yours, right? Besides which, they got an order to appear and they're still not here.
Well, he could. Yeah,
Yeah,
exactly.
but,
Get
what-
rid of it.
no, but the point of the order to appear is they gotta start showing up.
He could be the representative if he wants to.
I apologize. I don't recognize that store, so I don't want to speak to them.
Next, we have case 33325, Oceanside 7-Eleven Incorporated, number 34227, renewal of grant to maintain one double-face illuminated detached ground sign, setback 5 feet from Long Beach Road and Cortlandt Avenue and within the clear sight triangle, also known as 3274 Long Beach Road.
I think that we will note for the record that no one has appeared on this case, that this case was previously on June 25th, at which point no one showed up and an order to appear was issued by our office. I presume it was properly sent to whomever was supposed to respond, and we again have the person not here. This is a case involving a sign that's also in the clear sight triangle, so that does from time to time present safety issues. So I think that as a board, we will discuss how to handle the matter. But, pardon me? Well, I mean, I just think we need to discuss that the nerve of the applicant to decide to not show up even after getting an order to appear, which the other people who got it showed up. We have to address this because according to counsel for the board, this has become an issue, a regular issue of folks not showing up to resolve the matter. And there's a reason these are renewed. So we'll just keep it on our calendar until the board deliberates and figures out. No, right now we're going to keep it on our decision calendar and we'll figure out what we're going to do about it. When we hold John, the chairman here, et cetera.
Here's what the letter says.
Okay, fine.
That's
Yeah,
the
well,
action we
that's
should
the
take.
point. Well, like I said, we're going to deal with it as a board when we have the chairman here. Okay? So I guess we need to adjourn for until the afternoon? Do I have a? Second? Well, we can adjourn the hearing though, can't we? Second?
Second.
All in favor? Okay.
Back on the record, we're going to do decisions from today's calendar, and perhaps, with any kind of luck, some decisions on the reserve calendar. All right. Case 434 of 2025, Carlos Bolanos. That was renewal of a grant. Do I have any questions from the board? If not, do I have a motion?
I have a motion, file number 43425, Roosevelt Carlos Bolonos. Renewal of a grant to maintain two-family house be granted with 5 years, same conditions.
Second?
Second.
All in favor? Aye. Any opposed? Next case, 435 of 25, West Hempstead, Maria Tsakas. That's also a renewal of a grant to maintain a two-family dwelling. Any questions from the board? If not, do I have a motion?
I make a motion of 43525, Maria Zakis, renewal grant to maintain two-family dwelling with conditions, 5 years.
5 years, same conditions. Second, all in favor? Any opposed? Case 436 of 2025. This is a trifecta on two-family dwellings. Gladys Beltran and Fanny Velasco. That's at property at 479 Emerson Avenue in Baldwin. Any questions from the board? If not, that was placed on second call. Huh? Okay. Any questions? If not, do I have a motion?
I move,
I granted an appearance waiver.
I move case 436 of 25 Baldwin, Gladys Beltran and Fanny Velasco, located at 479 Emerson Avenue, be approved as requested, 5 years. With
Same condition.
Yeah,
Second, all in favor?
Aye.
Any opposed? All right, cases 437 through 439 inclusive, Elmont Allen and Kimberly Shamoon. These were also renewals.
He wanted the fence permanent, but
No.
clear site.
One, property address is 140 Evans Avenue, if I have. Any questions from the board? If not, do I have a motion?
I move that cases 437, 438, and 439 of 2025, the property is at 140 Evans Avenue in Elmont, that the cases be granted for the same period of 5 years with the same conditions. That's all.
Second, all in favor?
Aye.
Aye.
Any opposed, any abstention? Case 440 of 2025, Merrick Barbara Wood. Wood. Barbara Wood. Okay, any questions from the board? If not, do I have a motion? Property address is 1550 Northridge Avenue in Merrick.
I move that, any discussion? No, okay. I move that case 440, 2025 Barbara Wood at 1550 Northridge Avenue in Merrick be granted as requested.
Hold on a
Second.
minute, hold on a minute.
Hold on.
Why do I have an H?
I wrote an H too.
Yeah, well, no, that's right, we're gonna hold that,
This for pool closure.
yeah, we're gonna hold it.
I
We're gonna
withdraw my motion.
put it, okay,
What was Ms. Lowe supposed to do on that one?
she was, there's a pool enclosure that has to be,
Oh, yes.
this is the one where they didn't file, there was no record of any inspections, correct? So we're gonna, before we, yeah, good. Nice to know you're awake.
That must be the
Thank you for that
Case 441 of 2025, Oceanside, Robert Dietz. I won't go through it. It's 551 Fur Place in Oceanside. Any discussion? If not, do I have a motion?
Did anyone get the builder for that?
No, no.
I move that case 441 to 2025, Robert Diaz, the special exception to maintain a outdoor barbecue that, and, all the rest of the stuff.
Exceeding horizontal max.
At 551 Fur Place in Oceanside, that it be granted with the conditions that it should never be enclosed.
Second?
Second.
All in favor?
Aye.
Any opposed? All right. Case 442 of 25, Merrick Deo Gear. That's side yard maintain, the balcony. Oh, this was the balcony that was constructed contrary to the building department's recommendations. Any discussion, or we can have a motion? I think
I
it's
move,
going to be unanimous.
this is that case that when we looked at the history of it, they applied originally for a couple of balconies, including this one. But once they learned that this one would need relief from the zoning board, they decided they didn't want to go to zoning, so they then applied for a configuration that didn't need zoning, so that they were granted a permit for that. Shortly after that, they then amended their request back to this arrangement, which again needs zoning relief, and that was again rejected because it needed zoning, and they refused to do zoning. So after twice getting told they could not build this deck in this location without zoning relief, they built it anyway. And so to come now for zoning, I don't see how we can approve this deck that was clearly built after being told twice they couldn't build it and getting a permit to build a different deck. I am not in favor of this issue. I'm giving them relief for a self-created
Hardship.
condition or hardship when they clearly had knowledge of the situation. It wasn't even ignorance. They were told twice they couldn't build it here without zoning, and they did it anyway, trying to slip it through apparently. So I'm against this case.
Additionally, it's been there for several years. There's sliding glass doors that enter this platform deck. There's no railing on it. It's a safety issue. I think the building department and/or the Board of Appeals should give them a stern warning as to not use that.
Well, how about to make them take it off?
Well, that's
I
gonna
think-
take some time.
Right, but I think I'm in favor of denying this case and issuing instructions, a time limit during which it must be removed.
Second,
Second,
all in favor?
Aye.
Denial. Okay. Case 443 in Lido of 2025, Lido Beach, Richard Rubin. This was, well, I would have inspected, but I don't feel it's necessary. You want
Which
to
one?
inspect? All right, we're going to hold it. 443. Then
Okay.
maybe I'll go with you.
Yeah, I was going to inspect it, but I'm otherwise in favor of the case. It looked exactly like the rest of the neighborhood.
We'll all inspect it.
Yeah, yeah.
Okay. Okay.
Well, there's
Case-
other things, but where they're proposing it
All right.
is right to me, it's the best place because it's right next to the neighbors. All their equipment that's making noise and stuff is all contained right next to where they want to build in their yard.
Okay. Cases 444, well, that photograph, that aerial photograph that was provided by the applicant, I couldn't see what the hell was there. It was so foggy. I didn't know you could have built a nuclear power plant next door to it, and I wouldn't have known it.
My glasses.
All right? No, my glasses were working fine. Cases 444 and 445 of 2025, West Hempstead, Aslam Mohammed. Any discussion?
Just that the fence, if granted, should be, the 3-foot fence on the 1-foot curb has to be a temporary grant if it's granted, with instructions to remain the chain link that it
See-through,
is and
right.
see-through and all the rest.
And the portico is to remain open.
Oh, yes.
Problem with those two front doors?
No. You know what it was? If you looked at the house, I went to look at the house, so did Kimberly. There was a breezeway that was enclosed, and they kept the door there. I don't really have an issue with that. With the doorbell on it, because that was, if you looked at the primary door, did that have a doorbell on it? Didn't. Okay. Any other discussion? Does somebody have a motion?
I move case 444 of 2025 and 445 of 2025. Location of property is 166 Edward Court in West Hempstead. The variance asked for under 444 is temporary with conditions. And the 445 is temporary with conditions.
What
Second.
about no enclosure of the portico?
No,
That's the condition.
right.
All in favor?
Aye.
Any opposed? Case 446 in Baldwin, Fritz Michel. That's a special exception to maintain a second exception. That's the roof over patio with windows, which I thought was interesting. Yeah, it does. Yeah, but, okay. Conditions, no electric, no heat, otherwise they may... No electric, it was just for storage. No. I don't know. It was,
She said no electric. Yeah.
she agreed to it.
Yeah, she
No
said
electric, no heat. Who's going to make that motion?
I make a motion on file number 446 of 25, Baldwin Fritz Michelle, special exemption to maintain second accessory structure be granted with conditions.
All right. Second, all in favor? Any opposed? Cases 447 through 452 inclusive have been adjourned to October 15th, 2025 at 11 a.m. Partial testimony taken. 11 a.m. adjournments, case 331 of 2025, McDonald's.
Yeah, I move that case 33125. I grant it, or I move that.
Same conditions, temporary.
5 years.
5.
Second.
All in favor? None opposed. Case 332 in Wantor, 711, 18991. That's right. All right. I was absent.
Okay, so I make a okay, sorry.
So we're on the 333?
Yep, 332.
All right, so
332.
I'd like to hear what everyone has to say,
No,
but,
we're in 332.
oh, I thought we were already.
I didn't make
All right, case 332, 2025, the property's at 3382 Park Avenue in Wantagh. This is the 7-Eleven sign renewal. And do we have any discussion? If not, do we have a motion?
I move case 332 of 25 Wantagh 7. Oh, it's my turn. Number 18991, located at 3382 Park Ave, be approved as requested. Temp.
Second.
conditions.
Same condition.
Yes.
Second.
All in favor?
Case 333 of 2025. Oceanside, 711 Inc., 34227. They didn't show up again.
Wait a minute.
Is that right?
Hold on. This is the wrong letter, Joe.
No, it's a generic letter.
But that's the guy who showed
But
up on.
it's a generic letter.
Oh, you're saying this is his, but the same
Yeah,
one went.
that's,
Did it have the same dates? Yeah.
yeah.
Okay, so I just want to say that on or about June 26th, the letter was sent by the board after the applicant refused to appear on June 25th, indicating that the matter was moved to today at 11 o'clock, and notifying the applicant that, and I quote, "If you or another party do not appear on August 20th, adjourned date, this case may be dismissed or denied." The issue here isn't just a one-time oversight. This is becoming a pattern with some of these franchises and/or corporate stores, whichever. Particularly, we've noticed it with regard to 7-Eleven. Counsel to the board, in addition to us sending them notice of the first hearing they didn't appear at, and in order to appear for today's hearing, I believe counsel to the board has had some additional communication, either by email message or on the phone, indicating to the applicant the importance of appearing. So I am in favor of taking whatever steps necessary to dismiss or deny this case, whichever is most advisable, and notifying the applicant that such has taken place, with the view toward them understanding the importance of appearing and us figuring out how that would be resolved in the future. And that may include sending the building department to, issue violations, but I was
Right,
trying to think of a
I
different
think
word.
it should be sent back now to the building department. If they issue a violation or a ticket, then they're going to have to respond maybe in court,
Right, but in addition to dismissing it, you mean?
Denying,
denying it.
Okay,
or dismissal, because they could make an application.
Deny it, make them go through the hoops again.
okay, let's do that.
Okay,
So-
with
You want to make it, Joanne?
With respect to case 333 of 2025, location of property 3274 Long Beach Road, it is a 7-Eleven. I move to deny this case.
Second?
Second.
All in favor?
Aye.
Opposed and abstained.
In addition, you'll send out the information. We'll send it to
And
the
send
building
it back,
department.
and send it back to the building department.
And advise them
And send some sort of notice to the applicant indicating it's been dismissed or denied.
tonight.
Yes.
Yeah, they'll get a copy of the decision.
She's quite competent.
No, I'm just saying, I'm making the record here.
The record's over.
No, for,
Once told to me, send out the bill. So the NCPC denied Popeyes. They did.
so what does that mean for us?
I understand.
We'd have to have a supermajority to approve.
Cases 445, 446.
So,
Yeah. Cases 445, 446, and 1384 of 2024, Oceanside, 3359 Chicken Corp. DBA Popeyes.
I inspected this case, took photos, I think I shared them previously with members of the board. I found it to be an inappropriate place to have the Popeyes for any number of reasons, including parking, traffic flow, safety of pedestrians and other vehicles. It's an overuse to me, in my opinion, it's an overuse of that site in that area, given, Popeyes is a very popular restaurant. I hear it's very good. But again, that means a lot of cars, a lot of people, and I just don't think the site and/or the surrounding neighborhoods or the streets are constructed in such a way to safely and efficiently handle the amount of traffic and pedestrians and parking that this sort of establishment will warrant, given its extreme popularity. That's what I have to say about my inspection.
Any other?
I agree. I inspected it also, and especially the traffic study to me didn't make sense because I saw all the cars. The traffic experts said that it wasn't going to increase any traffic or be a dangerous situation, but that was not my understanding when I was there. And I also find that the side street where people would have to come in on would back up, Long Beach Road would back up, and the current, the place that was there, the Big Banana, there's not enough room for a drive-through there,
Yeah,
in my
and that Big
opinion.
Banana served a lot of locals, like
Yes.
those residential neighbors, people would walk, my mother-in-law used to walk over there.
In addition to those comments, maybe there are others. I'm going to read the resolution from the Nassau County Planning Commission. I'll try to summarize it. The commission found that fast food restaurant with a drive-through at this site represents an over-intensification of development on a constrained site resulting in an extreme parking deficiency, 57%, and the inability to accommodate a second drive-through lane or bypass lane. Next, a singular drive-through lane with no second drive-through lane or bypass lane would prove problematic for patrons who would like to exit the drive-through lane midstream. Having two lanes provides an escape lane, prevents backups, and keeps traffic flowing more smoothly. Third, a queuing capacity of 7 vehicles to the order board may be insufficient in some cases with vehicles encroaching into the parking lot, and in more extreme cases spilling over onto Long Beach Boulevard. Next, a limited off-street parking provided may prove problematic for customers seeking to either eat at the restaurant or pick up an order at the counter. In such cases, parking spaces would be at a premium. To worsen the situation, employees may park on site, which would further reduce the available parking for customers, which may have an impact on the abutting residential neighborhood. Next, Long Beach Road exhibits a significant bend south of the subject property for vehicles traveling in a northbound direction that may affect the line of sight and may create a potentially hazardous traffic condition for those vehicles entering the site at the curb cut just north of Long Beach Road and Henrietta Avenue intersection, or with the possibility that vehicles in the queue are spilling over onto Long Beach Road. And finally, it should be noted that the site plan will require further review by the NCDPW Traffic Engineering Unit pursuant to 239F that ultimately may require further revisions to the plan. Anything else anyone would like to add?
I agree with that planning commission. I was there myself, and I agree with the comments of the, made by the previous board members, or the board members today.
It also doesn't fit into the neighborhood either, because although it's on Long Beach Road, there are houses right next to it.
Yes.
So, do we have to make a secret determination?
No.
Okay. So, can I have a motion?
I move that case 445, 446, and 1384 of 2024, the applicant is in Oceanside 3359 Chicken Corp. Doing business as Popeyes for the special exception to drive-through, variance in off-street parking, parking in a clear sight triangle, and install a drive-through window, a drive-through menu board and for the drive-through use. That this case, based upon the comments made by my colleagues on the board, the Nassau County Planning Commission recommendation that this be denied.
Second? All in favor?
Aye.
So was Mr. DeGrace. Mr. DeGrace and Ms. Adams were absent. All right, case 321, that was inspected, was it not? Yeah. No, we have the inspection report. They didn't find,
That was inspected, the inspector met with the owner of the property, and the pool house, the site, the interior of the pool house matched the plan provided, observed no signs of illegal occupancy.
Okay, so I will make one suggestion as well. In the event the board is inclined to grant this case, we did have the Merkin case, and that the board granted temporarily. So if that is something, that, you know, we have precedent that we have done that in the past.
To continue the monitoring.
Correct.
Is this the one where it looks like a separate trailer?
it looked like a trailer.
Yes.
Yeah, yeah.
It's a Banno pool house.
It's got to be 25, 26 feet long. All right? So if we grant it, we'll grant it temporarily. How many? 3 years?
3 years, sure.
3 years?
Yep.
Okay. Somebody want to make that motion?
I move that case 321 of 2025, the applicant is Crystal Wiggins. The property is located at 547 Keller Avenue in Elmont, that we grant the requested relief for a period of 3 years, renewable with conditions.
All in favor?
Aye.
Any opposed?
I'm not voting or participating in this action for the hearing.
Okay.
I have no update on case 386. I will
Yeah.
send the applicant an email. I don't know if you had a chance to take a look.
Inspect
Yeah.
87 and 88.
I did,
before.
I'll just, let's talk about that in
Okay, sure.
break and then.
So I do have a slight update with respect to the next case, page 2, case 392 of 25 in Uniondale. Okay, so the board asked that we look into the rules and regulations regarding rentals and occupancy, because the allegations that the neighbors had were that these were being used for, you know, housing for students at Hofstra.
Right.
So, the building department had no record of any permit, a rental permit. And according to the building department, as a general matter, your regular CAPE doesn't permit more than 5 non-related folks under one roof.
Can they do that?
They can't.
They can or cannot?
They
How
can't.
can they
It's-
say?
So New York State Property State Maintenance Code, they do have certain requirements when it comes to space and how many folks can occupy. Now,
This
when you,
just has a constitutional issue, you would think they could.
when you get to family, that's a different, I think, argument. But it's based on square footage. My understanding is that every bedroom needs to have 70 square feet per person. and then, well, for the primary, for one person, and then 50 feet thereafter. So there are actual numerical values that are assigned to habitability, yes.
50 square feet
For the additional person.
for a
So if it's-
bedroom?
Correct, so for two
Well,
people.
70 for one person, 120 for two.
Correct, and then it would be 170 for three. So that's what the code states. Now, they also state that there's no habitability in a kitchen, in a bathroom, but you can in the dining room and the living room. So it's,
That's a construction code.
okay. It's a New York State regulation. So Patrick and I did review the live stream, and the representations that were made on the live stream were that this was to be occupied by the applicant. It was not going to be used as a rental. So those are the
But,
representations.
okay, so
that
let
were
me
made.
back up. So if I say, oh, my house, I'm gonna occupy my house, blah, blah, blah. And then, 6 months from now, 3 of my college friends say, and my house is pretty big, it's got 4 bedrooms. 3 of my college friends say, hey, Kat, can we move in? We'll split the rent, la, 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 la. That I can do, right? Because I changed my plan. I have the square footage going on, so how many people can this house have?
So
You know?
the building department didn't actually review the plans for that house. They just gave me the general, your average cave, and apparently the area has many caves. Your average cave can house 5 folks.
Wait, so when we say this bedroom stuff plus people, if I have habitable space at these numbers, but 3 bedrooms, do I qualify or not?
So yes, because habitable space, you can occupy a dining room and a living room.
So it
but not a
doesn't
kitchen
have to
bathroom.
be actual bedrooms. I just have that much space habitable for each individual.
The calculation that I provided is for bedrooms.
The way to get around it, though, is they're converting the garage, and they don't have side yard aggregate, so we could deny it on that basis.
Well, you could deny the case.
In other words, my point is.
What is the garage
then
attached?
about how many people could fit in there, they need a variance to maintain the addition of the garage to go to living. It has nothing to do with how many people are living in there. If we wanted to go in that direction, I don't know what the law wants to do.
Correct, correct. But again, they did make the representation that they were supposed to be occupied.
Does this person have a family, do we recall?
I don't know. It was Hugh Schaefer presented the case. The applicant was not here. But you recall, the neighbors came and they were
Yes.
saying that the 4th of July parties and all that. So, we don't have to make a decision today. But
And the
that's the
applicant
information
does-
that I was
I'd like to
able
look
get.
at the
The applicant does-
layout again.
the
I think I'd like to look at the plans, the
The-
layout.
The individual who presented the case made the representation that it was going to be occupied, that the gentleman, the applicant was intending on living there. So then, I mean, that begs the question, do you then make it owner occupied? Do you, they testify to it, so again,
I mean, are we allowed to tell them that they can't rent it out? I mean, they.
Well, what we could do is tell him he can't maintain the addition and the garage converted to living space. Theoretically, but that doesn't
it doesn't solve the
change
problem.
the structure.
It doesn't solve the problem.
I would grant it 2 years, 3 years, temporary, that it be owner occupied, as represented in the testimony.
I agree with that.
I mean, there was testimony to that.
I'm fine with that.
I mean, it could also be owner occupied, but you can make the condition that if they intend on renting it out, they obtain the appropriate rental permits.
Or we could say owner occupied and comply with all other, housing ordinances, laws, blah, 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 blah.
So, again, it's.
State, federal, muni, local.
So
All right, Joe, make a motion.
Correct. But again.
Because they have a past pattern of conduct, they believe.
Representation was made that this was to be owner occupied.
Okay, so let's do that.
The expediter states that he intended on living. So that's why it was kind of a moot point for the rentals, because it doesn't really matter, he intended
Well,
on
it
living
kind of
there.
isn't moot because we wanted to know what enforcement we have.
See, that's. Okay, just go ahead.
I was listening to you.
No, it doesn't matter.
It doesn't matter.
Christina.
Just go.
Okay, go, Joe.
I move that case 392 of 2025 in Uniondale,
tired of listening to
John
our crap.
Kopax, the variance for the side yard aggregate to maintain an addition and a garage converted to living space at 33 Manor Parkway in Uniondale were granted for a period of 5 years that it be owner occupied and, what? As testified to, in the hearing, and otherwise comply with all the New York State building codes.
Building and rental, et cetera.
All in favor?
Aye.
Opposed? Next case, 328 of 2025 Oceanside, Agro Holdings LLC.
We do have an update on that. The applicant's attorney did email the conditions over as requested by the board.
I don't like that.
Really?
Do you?
I didn't like that case.
Which one? This one right here?
I looked at it again, I still don't like it.
Yeah. I was just gonna say, I don't remember it now. It says that. I know, because I just go, I don't really remember that case. Now I look at it. So I'm all for that. Yeah. Oh, God.
Did you inspect 411?
It's so cold, my feet are
That's the one that we thought was by the school because they were throwing the garbage over, but it's really not. Upon my inspection, that fence forward of the house is not conducive to the neighborhood. When you
How,
set
can it
back-
be at all forward or no?
in my opinion, I would keep it against the house, the side of the house. You wanna give them a little break and move it up a
Yeah, like
little.
4 or 5 feet or something?
Yeah, that would be
Because it
fine.
would help their yard, and I think it would,
I have sympathy for them as far as helping their yard, but you start doing that, everybody's gonna.
I understand, but I'm just thinking like if it wouldn't probably change the impact of the sightline if it went out like 4 feet. I mean,
I'm open to compromise, I looked at it, I just thought that nobody else has that, and
I saw that in the Google Earth. That was the one we were
what
looking
does
at.
everybody think? Let's vote.
How far back is it from the street? How far away would it be from the street?
Well, 4 feet from the house, as you said, would probably be like 15, 20 feet from the house.
From the street, yeah.
From the street, in other words, they wanna move it all the way, they want it all the way at the street, which is not good. And usually I would assume that fence belongs
Normally
not
without a
forward-
variance.
Not forward of the house, which all the other houses on the block basically have. It would stick out. If you wanna give them something, let it stick a little.
Yeah, like on a hardship idea
If
with.
that's what you wanted to do,
It's a corner property, right?
Yeah.
Yeah.
If that's
I
what
would
you
be
want.
in favor of
But it's
giving
not,
a little.
but it's not on the corner, it's on the
It's
left
on the
side.
other
Yeah.
side, I see.
Okay, it's fine, so.
Yeah.
Want me to make the motion? or-
Yes. Maybe give them 5? I don't- If it's still gonna be 20 feet away from the street, they do have an argument, a hardship argument with the garbage thing.
Everybody in agreement on that?
Yep.
I make a motion on case 411 of 25, North Valley Stream, Regine Michelle, maintain 6-foot-high fence forward of the dwelling on Flower Road.
It's gonna have to be temporary. Because if
With-
they sell it, the next guy's gonna.
I went there at the, and inspected the property, putting the fence all the way forward of the dwelling would change the contour of the neighborhood. The board suggested that we give them a temporary grant of putting the fence 5 feet forward of the residence, and grant that temporarily for, how many years? 3, 5? 5 years, 5 feet forward of the residence.
I second.
All in favor?
Are you listening to 211?
What? Guys. All right. 590 Hempstead, cases 424 through 426 inclusive.
We gotta do some more work on that.
On what? Okay.
It was just the update, the NCPC did make the determination, they were awaiting amended plans, the applicant appeared to.
That's a good idea.
Unless you knock down the cellular, T-Mobile, the property is not big enough, you know, from Kim went and inspected it, and she went through the whole jazz, so like, really, they want to put a Chipotle there and knock the cellular thing down there.
I went by there, and I agree with, you gotta knock it down.
Want to make a motion? Anybody else?
I would agree with whatever the board comes up with.
I agree with that. I think it's gonna be,
Over intensification.
the kids from the high school that are gonna jam up that place like crazy.
Well, and the reason that I wanted to look at it again, which may not be necessary, was exactly because in looking at it and when we were in the hearing and hearing the testimony, I originally thought that closing the curb on Houston would be adequate, but once we talked with the applicants about the whole flow issue, I realized that even closing the curb on Houston wouldn't solve the problem that I originally thought it would solve. So, that's probably back to Mark's point in that it's not big enough for the proposed use. So I'm okay with that.
And quite honestly, the applicant, the attorney for the applicant was here, but so were the people from Chipotle were here. And they were very inflexible as to whether or not they would be willing to change a curb cut. And
But again, the curb cut in the end that I thought would solve the issue, when I started out in the hearing, I realized when they started, and they did too, when they started talking about how the flow was gonna go that way anyway, it was basically, even if that's closed, here's the flow on that street.
Well, I-
So it's gonna
which-
make it more dangerous that you have to then make a right.
Right.
And when I went to
Turnpike.
inspect, and it was like 4 something, I took pictures, and the parking lot was already packed. Without the Chipotle.
And not only without the Chipotle, with an empty park. It wasn't like some other business, right? It was
Wasn't
empty.
in session.
Then we were talking about, was that Nassau Boulevard here?
No, the other one, Houston.
Houston, and there was two. There was one Houston,
there's
but then there's
Nassau?
Nassau Boulevard where you can't get, if you're coming
Right.
from the other direction.
caused the flow
cars,
issue,
you know, it was like a disaster.
Okay, somebody gonna make a motion
this
on
would
that
have been
case?
more palatable as a drive-through.
Maybe we can put
Quite
Popeyes
honestly.
there instead.
I make a motion that we move to adopt a negative declaration as to the Sequoia.
We don't need
No?
it.
No, we don't need it?
Is the board denying the application?
Yeah.
Yeah. Oh,
Gonna
so you
make a
don't need it.
motion to deny the application.
I make a correction, I make a motion, file number 424 of 25 to 426 of 25, West Hempstead, 590 Hempstead LLC, variance front yard setback on Nassau Boulevard, construct addition to existing building for proposed restaurant Chipotle, variance in off-street parking, parking in front setbacks on Hempstead Turnpike and Houston Road, and clear site triangles on Hempstead Turnpike, Nassau Boulevard, and Houston Road, variance front yard setback, Hempstead Turnpike, construct trash enclosure, install 6-foot-high fence forward a building line on Nassau Boulevard and Easton, which would obstruct line of sight substantially, be denied.
I second.
All in favor?
Aye.
Off the edge, they should go, across the street.
Twenty-five? Dunson,
I've,
as every, no, go ahead, go ahead.
I have reviewed this case several times. The applicant in this case is surrounded to the east by a Carvel and to the west by a delicatessen takeout. The applicant testified that he intends to buy the property to the,
Oh, this case.
lost you?
This is the
No,
case.
no, you know, I can intend to win lotto next week. What ensures that I'm gonna do that?
He wants to buy the property to the west.
I had
Well,
an
that's
issue with
nice
this
of him.
case.
And this is, the sale has not taken place, and this case to create a parking lot, which is substantially out of compliance because he also wants variances for that, is out of character and it's premature at this point.
And
So-
that's Christina Council.
Just the information, because we did speak to the building department after, so just, again, the facts, Mr. Pellegrini is correct. Carvel is selling off a piece, it's subdividing one lot that it has and selling it to the owner of the neighboring business who doesn't happen to own the land in which the
Correct.
business is situated upon.
So you're gonna
And-
create a parking spot unrelated,
Oh, I'll tell you about this, because it's a,
you're gonna create a parking lot.
So the intention is to create a parking lot that would service the neighboring business that the applicant doesn't yet own the land to, but again, he owns the business.
but also, if he owned the land of the business, some of the, many of the variances he wants now for that parking lot, like the backup,
Correct.
would be moot, because it would back up
Correct.
into the property he now bought, so he wouldn't need backup variances and all these variants. It's a very, I'm not crazy about this case, it just all seems like it's in the wrong order, and we really don't give parking lots as just an independent thing, not legally tied to a particular other piece of business, but
Property.
My,
Property, not
In
business.
my opinion, it is premature and should be dismissed without
tell
prejudice.
us what you have to say. Legally, what do you say about it?
legally, I mean, it's the gentleman who is trying to buy the piece of property to service a community that doesn't have enough parking, and he just doesn't happen to own the land in which his business is situated in. That's kind of how I view this case. I understand there are other hoops. I do think that if, again, the board can't deny this, the board can do whatever it wants, I don't make decisions.
Well,
Obviously. I
No,
just
but
think
I'd
that
like to understand your,
it could be conditioned. I understand the prematurity argument, I understand that, but my understanding is that this portion of the property is for sale now. Neither parcel has insufficient parking regardless of this parcel. So if this parcel is subdivided and Carvel loses that parking, they still have sufficient parking.
Correct.
okay.
My Hero still has sufficient parking without this parcel.
Right.
So, again, I think that
But the issue I also have is, say we allow this, and we grant him these backup variants and all this stuff, okay? Now he buys the other property, okay? If, at the very least, I don't want him to continue to have those backup variances. It may sound petty, but I don't want him to be able to add some bunch more parking spots because he has a variance allowing the backup and all that sort of
But
stuff.
that's where it could be conditioned, in that it is a temporary grant, that it, upon purchase of that lot, they must be merged, the variances,
And what if he doesn't get that?
Didn't he say?
it's, well,
Can we have some conditions for that scenario too? Maybe that would make it palatable.
sure. Correct. Correct.
My motion, I move to dismiss the case without prejudice.
They don't sell it, they want the, they don't want to.
What if we had,
There's no guarantee that the parcel will ever be sold.
what if we have
There's a motion on the
conditions,
floor
but what if we have
to
conditions
dismiss it
that
without
say,
prejudice.
in the event,
There should be no discussion after that.
I would,
With respect to everybody.
I'm just, my recollection, and from and I was not here, I didn't listen to the case, but my recollection was, as long as I'm on this board, we have never, ever created a parking lot, legalized a parking lot that was unrelated to anything else. And if there is a motion on the floor to dismiss without prejudice, they can always bring the application
Yes.
when he buys the property, if he buys the property. And by your own admission, that business is not lacking for parking, nor is the Carvel.
It's not that they're not lacking, they have sufficient
They have
parking.
sufficient parking,
But-
so where's the hardship in
Second by
dismissing the
motion.
case?
Well, I think we
All
can-
in favor?
I think we could have created conditions for when he
Dismissed
did or
without-
didn't buy that.
Okay, so it's JP,
We have a motion on the floor to dismiss without prejudice.
okay, you're out, so. Okay, I got that.
Okay, who's in favor of the motion to dismiss
You have two.
without
Three,
prejudice?
four, five. Okay,
Okay,
so you,
and that,
I would like to discuss further.
and it, you're gonna create conditions where none are necessary. All right, what else do we have on the referral calendar? Oh, let's go back to agro.
yes, I gave you the,
So here are the proposed conditions, and I would prefer that someone else read them because I would deny this application. I didn't like it the first time, I won't like it
Agro,
the
the one
second
in
time.
Oceanside, it's on reserve, page 2, I believe.
That's the one where your outdoor parking of construction
Yes.
vehicles.
Those are the conditions.
We kind of boxed them in to see what, and.
Go
yeah,
ahead.
I'm interested in seeing what this says.
Yep.
Yes.
On this one?
Me too.
Good,
Kim and I.
That's why I
okay,
don't-
okay.
I'm never crazy about the outdoor parking in Davis, particularly
Well,
where
we've got
Do
a,
you want to,
we've got a situation on Franklin Avenue.
that's,
we got a lot of those on Long Beach Road that I go, that was
she should
young
read
now.
it. She should read it, I'm not going to read it.
I wasn't here for the case, so I have no idea.
It goes to house, it goes to house.
You want this read, Chairman,
Yeah.
or no?
If you're gonna vote on it,
I-
I know what my vote's gonna be, but you may as well read it.
Okay, this is with respect to case 328 of 2025. Location of property is 2864 Woods Avenue in Oceanside. This letter was received by our attorney from the attorney for the presenter of this case, Dominic Minerva. The proposed conditions from the applicant for the board to consider are as follows. There shall only be permitted the overnight outdoor storage of 5 pickup trucks, 2 of which are permitted to have dump bodies attached, and 1 backhoe model case 580N. See attached specifications for dimensions. Number 2, this shall be in addition to the 1 backhoe stored inside the building. Number 3, the overnight outdoor storage of any other commercial vehicles shall be prohibited. Number 4, applicant shall install a strip of evergreen plantings, a minimum of 6 feet high when planted along the south property line. Number 5, there shall be no loading or unloading of material from any of the commercial vehicles. Number 6, there shall be no storage of material such as gravel, soil, and asphalt at the site. Number 7, there shall be no repairs to the vehicles performed at the site. Number 8, any commercial vehicles that make a beeping or other alert sound when operated in reverse shall be stored with the front of the vehicle facing outward. Number 9, the backhoe shall only be stored on the Woods Avenue side of the building and not behind the residential dwelling to the south on Court Street. That is it.
I think that's exactly what they attested to.
Yes.
I did ask them to reduce it in writing. They did reduce it in writing. I'm satisfied with this. I would allow them
I was shocked
a
about that,
temporary period
I would not have
if
thought
it
he would be
goes.
agreeable to that.
I second that.
So,
Well, I didn't make a motion yet.
Oh, I thought you did.
No.
On one hand, it's a commercial area, I understand Woods Avenue guy came in there, and remember the lady that came in with her husband, and she was saying how it was going to affect her life and everything. I was just like,
Well, I live in that area. I go down Woods Avenue probably every day. Woods Avenue is busy. I mean, there's a lot of commercial properties there, but I have never seen, other than maybe twice a week, that there are 4 vehicles parked on that property, probably with respect to the barber shop. I have absolutely no problem with that being there.
My opinion?
Yeah, of course.
My opinion is I think it's totally inappropriate for outdoor storage of vehicles of that type at that location. It may be a commercial area, but this is borderline semi-industrial or industrial area.
And there's a lot of
I've seen that happen in other locations, and I find it patently offensive. And if you're gonna park dump trucks next to a residential area, and that whole block south of that is residential, I wouldn't want it happening in my neighborhood, and I would vote to deny it. That's my
I mean, I happen to, in looking at this here and looking at the type of backhoe that's referenced in the materials, it is residential everywhere except across the street from him, there's a few businesses, but not industrial.
Go down the street,
not
there's a
to
big
this
service
extent.
station. That service station probably has 15 to 20 vehicles parked there every day.
That wasn't the way it was when I was there. You know, I can't attest, I don't go down that way.
Well, I go down that way all the time.
but on one hand,
So?
Woods Avenue, I understand, like, over there is commercial, like,
Oh, yeah, Woods Avenue is not
And it's not
commercial.
even an interior lot, it's a corner lot.
side streets towards where the Eden Nursery is, those are all residential now.
Well, that's true, but no one else came in, did they?
I agree with you.
No one else came in.
Well, take the vote, make a motion, take the vote.
I mean, it's right next to a residence there.
What, that letter, what, it says with dump bodies, what is that?
Yeah, dump trucks.
Yeah,
And then you wanna put up a 6-foot high screen? 6 foot high, how high is a dump truck?
Well, how about the back?
well,
There's no way dump
we didn't say dump trucks, he was gonna get rid of that.
No, the bodies.
Yeah,
There'll be a,
2 of which have permitted, dump bodies attached.
bodies attached, but it's not a,
I don't know what
It
that
looks
is.
residential to me everywhere.
what Thompson does.
I mean, I
The what?
residential.
Can we, just a minute, can we table the case so that people who were not at that hearing can review the videotape and familiarize themselves with the area and just hold it?
In addition to that, Chairman,
Wait a minute, there are 2
I'm
people I thought who were not.
Okay, so you guys are looking at
Couture and Kim weren't there.
Okay, because I was just looking at up here.
No.
Yeah.
Kim and I.
So they weren't there for the afternoon session. They weren't out all day. Because normally we have the,
So I'd like to table the case, let them familiarize themselves with the video and with and inspect it.
Chairman, I would also, in addition to that, I would like to see more clarification on this pickup truck with dump bodies. I don't know what that is, I don't,
Remember when the guy was testifying, the owner came up and we were asking him what constitutes, how full was the truck, because we didn't know
Yeah.
what constituted that, and I still didn't get from that.
it's,
Well, a dump truck is really high.
it's, that's the,
Well, the way he explained it was sort of.
Ask him how many lug nuts it has. Good indication.
how big it is.
Yeah. 3/4 tons on 8, yeah.
Yep. Well, 6 foot under
It's a
any set of
concrete lot.
circumstances is not good.
it is a concrete lot,
Where would there be shrubs? It's a concrete lot.
next to the neighbor.
Bordering the residential property.
So ask for clarification of what a
We'll see him this afternoon. I will.
dump body is. It was
There
Minerva.
is dirt for about 3 foot width right there. That's where you would want to put, that's where you want.
Did that come before us? It may have been town board, but it could have been town board.
You would want to put it, but 6 feet is not.
Yeah.
So,
How'd you try it?
No, it isn't.
all right, so we're going to table it. Folks, we're going to table the case to allow two of the board members who were not present at the hearing
I-
to familiarize themselves.
I think that's prudent, yes.
Yeah, because I have excavation.
And what else?
Would you like to deal with the additional administrative things we have after?
No, how many do we have? Let's do it.
Okay, fine.
I'm not going anywhere. Oh, okay.
Yeah, you can, it's a good idea. And then, you just gotta come over.
We have two for
By 9 o'clock.
administrative review. One, the board will recall 666 Old Country Road. It was the Zinberger that the court approved. So
That was
they're
my
now making modifications. They lost the deal with Zinberger, so they're making modifications to the site, which would, so it's in an industrial zone, if I'm not mistaken. So they're proposing a drive-through.
It's on the ring road of the mall.
Yep.
They're proposing a drive-through, which technically takes away parking spaces, but since they're making it a drive-through instead of a sit-down restaurant, the amount of spaces that they need goes down.
But wait, do we know if, so this is in the parking lot of the parking for the building?
Yep.
And do we know that it's not taking any spot, does the building have adequate parking still?
The building will actually, the deficit goes down because they lose a net amount of spaces, but they require less.
No, I mean the building that, whose parking lot is in.
If,
So
Just a
it's
second.
proposed in the parking lot of the building 666, the office
Did-
building. So it will take away some spots from the office building. That's all I'm asking.
Well, my
That
understanding,
has underground parking as well.
Yeah, it does.
my understanding, so if you'd like, I'll read the highlighted portions. This is from the
just a
building
second,
department.
hey, gentlemen,
Go ahead.
they're not familiar with what happened, the whole flow. It went to court, it got denied, and,
Long
I know, but
This is long before me. I just mentioned that. But there was an Article 7, the board denied a case, if I'm not mistaken, twice. There was an Article 78 taken, the court granted the variances. So now the board is stuck with that. I believe, didn't the board appeal it, it went to the second department? Anyway,
I don't know about that.
so now, since a lot
is,
of
is
time has
the,
passed,
right now, the court, it's in the court and it got denied.
no, the court granted.
The court granted the variances, they
Granted
needed to construct a
variances.
Zinberger, but they lost
Okay,
the contract.
okay.
Correct. So they lost the contract with Zimberger. So now they have this grant, they're changing the tenant, so they want to change it from being a sit-down restaurant to a drive-through. Now, a drive-through in the zone in which it's in does not require further relief from this board.
No, because otherwise is the court's decision, does that apply to this as a new case?
Yes.
Yes or no?
The granted relief does, I would assume.
Does it?
Variance is drawn with the land, same land. So if they granted, my understanding is that they granted the restaurant and a parking variance.
So like if they put a tenant in that needed the exact same stuff, they wouldn't be talking to us.
And so they needed FAR and they needed parking.
Did-
And they needed parking. Those were the variances that were in front of the board.
And the court said they don't have the authority to grant the
Yeah,
case.
they did.
They did.
That's better than telling us to do it. I am offended if they tell me to do it.
Correct. It's because they're changing their plans now. So that's why they're back for administrative review.
Okay.
So can we let her know? Tell us what they,
So again, based on the materials that were provided by the applicant's counsel and by the building department, the modifications that they're proposing require less relief than what the court granted. The floor area ratio remains the same, but the parking relief goes down.
and those are the only two things we grant,
That
the
was
court
the
granted.
court granted. That was my understanding.
Okay.
Okay? So there's an overall decrease in the amount of parking spaces, but the proposed drive-through use requires less spaces, so the
Got it.
deficit goes down.
Got it.
Is
So
it
what
drive-
do they want from us?
Administrative review, which I found to be kind of strange because the court granted it, not us.
Yeah.
So,
And unless they need additional relief,
they don't.
anything we would do, like if we said not acceptable,
What
they're
does it
gonna
matter?
just point to the court.
making another modification. They want to change the enrollment from 19 to 25, and that is based on the state who is permitting them to have 25 students.
So they meet all those requirements.
Correct,
that
so
many
that's
students.
why they're
So-
asking us for the modification.
Do they need more parking with it, or is everything else copacetic?
Everything else is the same,
Fine with me.
because it's kids.
The
So-
building department agrees that everything else is no parking, additional parking?
Well, I don't believe it was in front of us for, it was here for special exception to maintain daycare center in existing building, a waive off-street parking, and no provisions for pickup and drop-off. So it was a waiver that the board granted.
We waive 10 spaces, 100 spaces?
Okay.
Who knows?
I'll look into it. Yeah, no, that's fine. That's fine. This is the one on Grand Avenue. We'll look into it further. There was not. I believe,
It's not
I
gonna be much
believe,
more parking because it's a drop-off thing.
Just
But-
because the state says it's okay, that doesn't mean we do.
that's fine. Well, I'll speak to. Mhm. I thought that there was wasn't there a municipal lot right behind? And isn't that how they were doing the drop-off and pickup through the municipal lot that's abutting the premises? That's what I recollect. There is a new building. And that's why they asked for the modification for weekends.
Because they have more.
Because now correct. So that's why they asked for the modification. It's in Baldwin on Grand Avenue. So, okay, we'll table that, that's fine. You want me to find out how many more spaces we need? I will do that. That's fine. Even though we granted a waiver, but I'll do it, it's fine, it's fine. The next one we have is more administrative, strange case. It was a subdivision that was presented back in 2019, a 5-part subdivision, and for reasons unknown,
I know this is
the location of our cards and the location as it was captioned on our calendar is different than the location that was written on the notice of decision. So they are requesting, they are requesting that we modify our decision solely to reflect the correct locations, which again, we had on our calendar, and that we had, okay, now there's one more, which I think the board will be happy with. One of the cases is a request to delete 3 variances, which we granted that they don't need.
Great.
Okay, so if anyone would like to make that motion,
I will
these
make
are the
that
case numbers.
Did you verify that with the building department?
Yes, we did.
Okay, so I would move
We
as
did.
it relates.
Okay.
All right,
Yes, Kate.
case 282 of 2019, that we amend the decision reflected in our grant to properly show the decision that it was actually supposed to pertain to, which was also included properly in all the other materials. As it relates to case 284 of 2019, I move that we amend the decision to delete a couple of variances that are no longer required, in other words, reduce the grant we made. In particular, I would like to delete the lot area occupied variance, the rear yard variance, and the side yard aggregate variance. And then as it relates to that same case, we also need to amend the location there. All in favor? Aye.
Yami Majid Belmore LI. It's the mosque on Newbridge Road in North Belmore. This is the one,
Go ahead.
this was the one on Newbridge Road and Belmore Avenue by the school. They were trying to construct an addition. It was very oversized. There was no parking. They went back to the drawing board, amended the plans, and now they're coming back we adjourned it without a date. They're looking to be restored to the gallery.
So did we ever hear it
To
or
the
not?
queue. It would be
We never
restored
heard
to the queue. No,
All right.
it was adjourned several times.
All right, we have it's in ADA, so they want us,
They want us to restore it to the queue, because it has to be re-reviewed. They've substantially changed their plans.
okay, I move as it relates to case
Probably about 3 months.
As it relates to case 765 of 2023, as it relates to 765 of 2023, it looks like it is called Jameh Rajid Belmore L.I. Inc., 1425 New Bridge Road in North Belmore. I move that we restore this matter to the queue. It was previously adjourned sine die, so that all the other proceedings can, take place in order to eventually maybe have it on the hearing calendar.
Second. All in favor? Aye.
Good, I like it when it's easy administrative stuff. Adverse issues that, I would move then that application, I don't have a case number. I would move that case number 806 of 2022 be restored to the, give them a rehearing on the matter that was previously granted by the board, but for which other administrative issues caused them to run out of relief to permit it.
All in favor?
Aye.